Good morning, everybody. Welcome to the resumption of the hearings on the Wellington City Proposed District Plan. This is hearing number 6, although it hasn't been given a number. It's just called the wrap-up hearing. So welcome, everybody. Today is scheduled for primarily council officers and legal submissions. The whole day has been scheduled, but discussing it amongst the panel, I don't think we're going to need the whole day, so just some advance warning there. The usual provisos, please, around phones being off or on silent. Thank you. So the schedule for today is Mr. Wellington will take us through his legal submissions. Thank you. And then we'll go to Mr. McCutcheon to hear his report and ask him questions around the outstanding submission points. And then following morning break, we are scheduled to then turn our minds to design guides with Ms. Stevens, Dr. Zamani and Ms. Duffel. There you are. And we'll just see how long we'll need to go through all those as well. Thank you. I think that's all the sort of presumptive things I need to say. So, Mr. Whittington, the floor is yours. Thank you.
Thank you. I was going to start by introducing the various people, but I clearly don't need to. I will mention, though, Andrew Banks from Boffa School, who's also behind me. He was obviously heavily involved in the design guide process. Rather than going through my submissions painstakingly, what I thought I would do is effectively jump to the Waikanae Land Company case at 2.6. I don't think you need to be recapped about qualifying matters and NPSUD. I'm sure you've had quite enough of that in the last 5 hearings. So the update that I have for you on that Waikanae Land Company case is that there's a hearing set in February 2024, which means it's highly unlikely that there would be a decision before you release your recommendations, but it is possible if the court has some writing time and decides to get a decision out very quickly. So there could be a spanner in the works late, or it may confirm my submissions to you that I don't think that decision is rightly decided. And the other part of the update that I've given you in that part of my submissions relates to the way the Kapiti Coast District Council has dealt with it, both the independent hearing panel and the council itself. The decision, or the recommendations, I should say, of the panel I've quoted, and in particular, I thought I would just draw your attention to paragraph 195 of that report, which comes up with an alternative scenario that in my submission is quite instructive, and it relates to the council perhaps identifying flood-prone land that had not previously been identified as flood-prone on the approach that the Environment Court takes to that situation. All that the council could do in the IPI would be to disenable the MDRS, leaving the operative plan still providing for some level of development, even if that was now inappropriate. And the report considered that was not consistent with Section 80E, and that it would be within the ambit of Section 80E for the council to go further than simply disenabling the MDRS and actually provide for no more development at all, and I agree with that.
Mr. Whittington, has there been a fulsome number of Section 274 parties on this case, or the equivalent, whatever? Assuming that section still exists.
It does. Yeah. My understanding is that it's a council appeal from the Environment Court's decision, which is on a resource consent application. The developer consent applicant is a party, but and iwi are a party, and I assume that iwi is a party as a Section 274 party.
Yes. The old concept of 274A, I think, was people who had an interest greater than the public. Does that still exist?
Yes, it does, I believe. Okay. Yeah.
And no other local, I guess what I'm getting at.
Nobody joined, and I'm not sure you can join at the High Court stage anyway. Yeah. So if the parties who were before the Environment Court were the council, the developer, and iwi.
Okay. Suffice to say, there's a lot of interest in the outcome.
Yes. I'm sure up and down the country, everyone is waiting with bated breath, which is why it's perhaps a shame that it wasn't given much more urgency in the High Court.
Do we know who the presiding judge is?
I don't. It's possible that the parties know, but I didn't ask that question of them. I just asked if they had a hearing date.
Thank you.
The second case update is the Port Otago Supreme Court decision, and I know you're aware of that because there's been some minutes released about, in particular on natural hazards, asking council officers to ensure that they undertake a structured analysis, which will become the new catchphrase, I think, out of that decision when trying to reconcile potentially conflicting policies of national policy direction. So that will be relevant to how the panel reconciles or deals with the New Zealand Coastal Policy Statement and the NPSUD, which in areas where they overlap, residential areas in coastal environment, may require some reconciliation through a structured approach. So I won't take you in detail through that because that perhaps can best wait until the written response that you're going to be getting from Mr. Searle.
Are there any other relevancies to the hearing process to date, do you think?
Well, potentially there's also, I can't think of any particular scenario, but if there are conflicting policies of the NPSUD itself, I can't think of any scenario that's arisen the way it seems to arise quite frequently for the Coastal Policy Statement, where you can point to different policies pointing in different directions in a particular given scenario, whereas the NPSUD does all seem to point in the same direction. But if you found yourself in a situation where you were struggling to reconcile policy 3A, maximising the benefits of intensification, with something to do with policy 4, perhaps in a qualifying matter area, I don't think, I think that the law provides for a separate way to reconcile that. I don't think that would be a Port Otago situation. The law has provided section 77 I, J, K and L, which assists you to determine whether a qualifying matter has been established that justifies a modification. But I suppose that the next question, if you're satisfied that there is a qualifying matter established, and the next question is, to what extent do we modify the MDRS or the policy 3 requirements to account for that qualifying matter? How you go about that analysis might require a balancing of the different policies, and perhaps that's, I wouldn't say you have to do a structured approach, but at the end of the day, that question is guided more by the legal provision requiring it only to be modified to the least extent necessary to give effect to the qualifying matter, to accommodate, I should say, the qualifying matter. So I mean, trying to imagine a case about that going all the way to the Supreme Court, I imagine the Supreme Court would say that the RMA has provided the method by which you go about that task, rather than needing to adopt or co-opt the structured analysis into that.
And the analytical framework that's referred to in that last paragraph of 81, presumably the court provided that earlier on, did it, in terms of, was it a step-by-step approach, was it?
Well, as I understood it, it was really talking about the structured analysis that they refer to in 78.
As they say, rather they are disciplined, and through the analytical framework we have provided to focus on how.
Yeah, from about paragraph 50 something in the case. I do have it here.
The reason I asked this is that the Supreme Court have done a bit of the heavy lifting that the National Planning Framework was supposed to do.
Yes.
Yes.
So what they do from 60 through to the paragraphs I've cited is go through the relevant ports policies in the NZCPS identify the conflict.
Yeah.
They then, from paragraph 72, address the question of where that conflict should be addressed, by which they mean, is it in the regional policy statement, or should it be in a district plan, or should it be in a resource consent context? What's the appropriate sort of
mechanism
stage?
here? Yeah.
And they accept the submission that any reconciliation of conflict between the NZCPS avoidance policies and the ports policy should be dealt with at the regional policy statement and plan level as far as possible. What isn't clear from their decision, at least as I've read it, is whether that is a statement of principle that, if possible, reconciliation should occur at those plan levels, or whether it is specific to those policies. As I've read it, it's specific to those policies. It may be in a different context. It's not possible to do it at a regional planning level, and it has to be the consenting level, for example. But I would have thought that, if possible, it should be done as high up in the process as possible.
Yes.
Recognising that you won't be able to reconcile them necessarily for all situations. There may have to be left an area of grey that allows for specific circumstances to be addressed in a consenting framework. One other thing, just by the by, which is quite interesting in it, is that I think after King Salmon, there was very much a catch cry of avoid means avoid. And they appear to have, the court appears to have just pulled back ever so slightly from that, because it says that avoid can mean something. You can avoid something if you nonetheless avoid material harm to it. So in other words, you might allow an activity because the effects on an interest that need to be avoided can be avoided, because even though there will be some effects, they will not cause material harm to that interest. Yeah. So it's not quite as absolute as it might have been thought.
Two things there. Firstly, was that a principal determination or an obiter? Was that part and parcel of the appeal, or?
That's a good question. I would have thought that in one sense it doesn't matter, because it's the Supreme Court.
Sure.
So,
and that's the end of the line, isn't it?
Line anyway. So it probably is, even if it is technically not a principal part of the decision, it is still so persuasive. Yes. That I would imagine that it would be followed everywhere.
Yep. And secondly, the pulling back on avoid, was that a particular reflection of the MP coastal policy statement, given that some of its language is a little bit more tempered than straight avoidance policies that you might, I'm thinking of the port zone and coastal stuff.
Yeah, I mean, I think it is specific to the NZCPS, in the sense that in the context of a different policy statement, the word avoid could clearly just mean avoid.
Yes. Or in a district plan, or.
Yes, that's right. So it would be contextual. I mean, I'm looking at 64 and 65. Although the court's talking about both King Salmon and Trans-Tasman, they're making it clear that they're talking about comments applicable to the NZCPS in both cases.
Yeah. Well, that's useful. I hadn't appreciated the comment on avoid at all.
It's interesting. I hadn't thought about whether it's. They don't go on, I don't think, to then determine that the particular policies can be reconciled because avoid doesn't mean avoid, as had previously been thought of. So I don't think that that's right. But if I return to after that question about where conflicts should be addressed in terms of the planning framework, they then go on to, at 76, go through the addressing of the conflict, and it's not an analytical framework in the sense that they've described it in sort of principled or descriptive terms. They just demonstrate what they mean for the particular policies involved. And so that's sort of 76 through to 78. And the two parts that I have quoted in my submissions are 78 and 81. And interestingly, they actually didn't remit it to the Environment Court. They had an appendix in which they provided suggested wording to be included into the proposed ports policy. So the council will have to, the regional council will have to decide whether to adopt that or not, but they did the work, which was quite interesting. Finally, we have the Natural and Built Environments Act, which, as I've set out there, doesn't yet apply in Wellington, or at least to this process. So I don't think there's anything in that legislation that changes your task or changes what you need to consider or anything like that. But no doubt that's some years away, or maybe not happening at all. We don't know. We'll know by Christmas. The last thing I wanted to talk about was the city outcomes contribution, because you've had Mr. Winchester's advice, and so what I've done in my submissions is set out where I agree with him and where I don't agree with him effectively. I have said at 3.2 that his advice is helpful in confirming a point that I had been sort of tentatively pressing, which was that you don't need a link between the effects of additional height and the provisions in terms of their justification. It's not fatal in terms of its validity, is the way that he put it. And the second point is that the provisions in the COC are not unlawful, as I think Kāinga Order and a few others have said, because they might duplicate regulatory approaches and other legislation like the building code. But Mr. Winchester considers, I'm at 3.3, that there are still issues related to certainty and the mandatory notification rule, and as a result of both of those issues, he considers there's, what it possibly does is reserve an unlawful discretion to the council. And what he's getting at there is that a person's activity status needs to be clear in the plan. It can't depend on a council planner's determination. So and so the concern is that depending on how many points are allocated, the person's planning status, the application's planning status may change. To go through those sequentially, Ms. Stevens had in fact determined prior to his advice, but in terms of the timing, I think it may have come out later, might have been filed or around the same time, that in fact it was more appropriate to use the standard notification provisions 95A to 95G. So in her further supplementary evidence that she pulled back from the mandatory notification provisions anyway. So that issue has resolved itself. And then on the question of certainty, I certainly, now at 3.6, I certainly agree with Mr. Winchester that there is a risk of that, but I don't consider it to be perhaps quite as much of a risk as he does. And I can take you through the reasons why, but where I end up is at 3.9, and that's a question of if you're satisfied of the merits of the proposal but question its lawfulness. It seems to me that that is a question for the council itself to determine whether it wants to take that risk. Certainly any reservations you have, you can record and should record so that they can be taken into account by the council in deciding whether it wants to adopt the rules and potentially be challenged through the Environment Court in a consenting situation when it comes to be applied. Obviously, if you're not satisfied of the merits, that's a different question. You can recommend what you recommend. But if it's only the lawfulness that you're concerned about, then in my submission, that's the appropriate course to take.
Oh, Mr. Whittington, I wasn't involved in those hearings, but that sounds perverse to me. I mean, surely at 3.9, panel doesn't want to be in a situation where it's setting the council up to fail.
Well, I don't think that it would be. So the process is, well, as I understand Mr. Winchester's advice, he hasn't said these provisions reserve an unlawful discretion. He said that there is a risk that they could be found to have that effect. I have the same view. I think the risk is less than he does, but nonetheless, it's a question of risk.
Yeah.
I don't think you would be setting the council up to fail if you are satisfied of the merits of the proposal, and you said we're satisfied of the merits, but we acknowledge this risk of unlawfulness. That's a matter for the council to determine. When the council comes to consider and adopt all or part of your recommendations, it will have the opportunity to take legal advice. It will do that in the way it sees fit. It might seek that from me. It might seek peer reviews. It might seek it from other people. They will have other information before them on which to make a determination whether it's a policy they wish to continue pursuing, and acknowledging that if challenged in the Environment Court, they will have to defend that position, and who knows where it will end up. But that's, in my view, that's a question for the council. It would be, if you're satisfied of the merits, but not satisfied of the lawfulness and therefore don't recommend pursuing it, the council can, of course, turn around and not adopt that recommendation. I guess what I'm saying is I think it's important that you record your views.
Yeah. So what are the options available? I mean, bearing in mind I'm wasn't involved in hearings 4 and 5, so I think this came up in hearing 4.
Yeah.
So what I'm hearing is that merits assessment first, and then there's some assessment of risk, and you're saying there's shades of risk, degrees of risk.
That's right.
But mere fact that there is some risk, shouldn't that be a red flag to this panel?
Yeah, absolutely. I'm certainly not saying that you should ignore that risk. I think that your recommendations should record Mr. Winchester's view, the submissions you've received from me, the submissions you may receive from other parties. No doubt Kainga Order's interested in that issue as well.
Sure.
And seek to resolve those if you can.
Yes.
But it will be a difficult issue to resolve conclusively as to whether it amounts to the reservation of a discretion. Partly because, thinking about it in a different context, the way that I imagine the High Court would address this, or the Environment Court would address this, is it would prefer to address it in the context of a very specific consenting scenario. So it's difficult to say right now it does or doesn't reserve an unlawful discretion. It's the sort of thing that it might need to play out through a consenting scenario to see whether the court agrees or disagrees.
I can understand that, but in terms of Section 32, we have an obligation to decide whether the provisions are appropriate.
That's right. And I agree that has both a substantive planning merits element and a lawfulness element. Absolutely. No difficulty with that. So
what are the options in front of the panel in terms of that realm? We might be getting into something that Ms. Stevens is going to pick up on again, or is it what are the options in terms of avoiding all risk through to accepting some risk? In terms of, are we talking solely about the mandatory notification here?
No, we're talking here about the provisions as a whole.
As a whole.
Because the way that they work with the points system is that whether or not a person complies with the policy or not depends on the allocation of points.
It doesn't affect the activity status.
No, so the activity status stays restricted discretionary. What does happen if you don't comply is that additional matters of discretion become relevant.
And notifications off the table.
Well, notification will
other than Section 95.
Yeah, it's no longer a mandatory notification. If you don't comply, mandatory notification was the initial.
And that's gone.
That's gone.
And there's no guidance there's no,
There's no preclusion or
No.
or mandatory notification either way. It's simply
Okay.
an application of sections 95A to 95G.
okay,
So the options are you look at the merits, you evaluate the merits and decide whether it's a worthwhile policy or not. Consider what the effect will have on development in the central city and in the different centre zones. And if you consider that the benefits of the policy outweigh the costs or outweigh the disbenefits, and you're satisfied that it's an appropriate provision, you can then factor in the risk that's been identified of unlawfulness and reach a conclusion as to whether you recommend it or not. But I think it would be helpful to the council for you to address both of those elements separately and indicate whether your view is based, for example, if you're actually going to not recommend it because of the lawfulness risk, it would be helpful for you to advise whether you think it's supportable on the planning merits alone.
yes,
That would be helpful to the
and to
council.
make our logic transparent.
Yes,
So
that would be
that's-
very helpful.
That's useful.
Isn't there also an additional risk to the council in taking a contrary view to the panel, particularly since the council would not have actually heard the evidence? And so if there was going to be a departure from what the panel recommends, that, it doesn't necessarily apply only to this issue, but there also is we're in the middle of quite a major process here. So if there is a departure in terms of the decision from our recommendation, that would need to be very, very well justified.
Well, that will be a matter for council officers and putting the information before the council when they have your report. What other information needs to be put before the council to make sure that whatever decision it makes is a lawful one. That was addressed in relation to the Auckland unitary plan. Because that was really the first occasion in which the sort of idea that you had a panel that made recommendations which would be accepted or rejected by the council, and then depending on acceptance or rejection, it would either go to the Environment Court or the High Court. And so where the council rejected the panel's recommendations, it went to the Environment Court on the merits, whereas if it was accepted and any party wished to appeal that, it was only on questions of law to the High Court. Here we have something slightly different, which is that if the council rejects a recommendation, then it can be taken to the minister for a determination.
And the council would need to provide reasons for that, the council.
Well, I have to go back to section 90.
No, well,
No, I'm not sure the council does need to provide reasons. It just needs to provide a report which indicates the parts of your report that it accepts and the parts of your report that it does not accept.
Okay.
The Kapiti Coast Council rejected a very high percentage, but there was one recommendation that it did not accept, and I don't think it expressed any particular reasons for it. I'll have to go back and check that. And if this is something you're interested in terms of process, and
what doesn't just relate to.
Oh no, of course. I'm more than happy to just.
Yeah.
We can move on with
Well, I guess
witnesses while I just do a little bit of extra checking of the provisions.
well, by that stage we'll be functus officio anyway.
No. I'm yes, you will. Well, yes, no, you will. Well,
I've just presented to the Hutt City Council,
I'm just thinking about the fact that the PDP continues.
but on the IPI.
Yes, although you have only been established by one instrument, I think so.
Okay,
I'll have to think about that.
Yeah. but our ability to get involved again is pretty limited and probably undesirable.
Yes, that's right.
I just presented to the Hutt City on the IPI. Fortunately, the council accepted all the recommendations unanimously, which so nothing to the minister, reasons or not. But the information that was given by Tim Johnson, the planner, to the council was that if the council did reject anything, they needed to provide the minister, whoever that might be, with reasons for the rejection.
Well, I imagine that is how it would go. The minister, as with the council, will have to consider all the information that's been put before you in determining whether to accept or reject the council's decision to reject a recommendation you've made.
Yeah.
And that will include, no doubt, the evidence related to that particular question or issue or recommendation.
Yeah. Well, thanks for that. I mean, I know we've gone a little bit off piece, but
no, I think actually it is a really important thing to think about as we move from, and this is of course the last IPI hearing as we move to the next stage. So I will perhaps hand over to Mr. McCutcheon, and I will just check through those clauses in the first schedule of the RMA to see what it says about reasons, and I can advise you a bit later.
Did you provide? Did you provide us with a copy of the Supreme Court decision?
No, but I can easily. I'll send an email through the hearing.
Be useful.
Thank you. Can
oh, right. It was 101 apparently.
just the only question I had was in relation to Kaingaora's legal submissions, in which they do question the whole issue, which you sort of summarised around the airport's obstacle communication services. Do you? I don't know if you've seen that or had the opportunity.
I have seen it, and I confess I wasn't entirely sure. I read the submission, went back to the minute in which the panel had asked for advice about how it worked and how much of an issue it was in practice. Mm-hmm. Read the council's response and assumed that because it is not really a practical issue, that it wasn't going to loom particularly large in your consideration. So I don't really have a response directly to Kaingaora's point.
Because they leave it dangling in para 4.8 that that not to classify the OLS as a qualifying matter and therefore not completing the necessary assessments. Leaves the question of whether the council or the panel have met the obligations under the MPS. So that's quite a question to leave dangling in the air. Mm. You may want to more considered response.
Yeah, perhaps let me reflect on that this morning, and then I will make sure I have an answer to you before the end of the day, as in at the end of our discussion, whether that's lunchtime or later.
Any further questions from the speakers? Thank you very much. That was very helpful.
Thank you.
Now we turn to Mr. McCutcheon. It seems like a very long time since we've seen you. Around the world. Okay. So how would you like to address your report? It's a very, well, it is a wrap-up, miscellaneous kind of ragbag, do I dare say, of matters to look through. How best do you think you want to talk to?
Good morning, Commissioners. What I thought I might do is introduce myself in the scope of the part of the report which I've written. Ms. Stevens will introduce herself and her expert witnesses for her part of the report. I've got a short statement to make about contact I've had with the submitter post notification of this report. And then I'm in your hands as to how you would like to proceed. I'm happy to take questions on any matter. I don't have any set structure or way that I've got in my mind about doing this today. To introduce myself briefly, so my name is Adam McCutcheon. I'm a team leader in the district planning team here at Wellington City Council. My qualifications and experience and compliance with the Code of Conduct for expert witnesses is set out in the 42A report. But very briefly, I have a Master of Planning degree from the University of Otago, as well as a Bachelor of Arts in Geography. The scope of part 1 of this section 42A report for this wrap-up hearing is determined by minute 27, which contains a list of submission points which have been, I guess you could say, deferred or left until this part of the process, given they are a range of miscellaneous matters, as it were, or they have been points which have been omitted or duplicated in the tagging of submissions in this process. It also includes some recommended definitions nesting tables, which is a recommendation which I made back in hearing stream 1, the first time I appeared before yourselves. It also addresses some advice which the panel requested of me in minute 29 relating to the notification provisions, the drafting approach and style of the plan, as well as the aforementioned issue of the obstacle limitation service, which we just discussed briefly before. I'll hand over now to Ms. Stevens to introduce herselves and her witnesses.
Thank you. Kia ora, Commissioners. So I'm Anna Stevens. I'm also a team leader in the district planning team. I've presented to you a couple of times now in stream 3 and 4. So as Adam mentioned, I will be talking to the Part 2 Design Guide, Section 42A, that I authored. My work experience and qualifications are set out in my Section 42A report. I also have a Masters of Planning from Otago. And I'm also author for the City Centre Zone, City Outcome Contributions, Wind and View Shafts, Section 42As as well. So the scope for Part 2 relates to minute 15, minute 23 and minute 24, and relates to the Centres and Mixed Use Design Guide, Residential Design Guide, Subdivision Design Guide and the Heritage Design Guide. So I'd just like to introduce officers and experts that will be supporting me, and then I'll leave my introduction to my section later in the day. So I'm supported by 3 experts, Dr. Fazad Zamani, so he's currently Tanaka Program Manager at Wellington City Council, but was formerly the Urban Regeneration and Design Manager at Wellington City Council, Ms. Sarah Duffel, Senior Urban Designer in the Urban Design team, and Mr. Andrew Banks, Senior Planner at Boffin Miskell. So I just want to note that Mr. Banks hasn't done a statement of evidence, but is happy to answer questions relating to the review methodology of Boffin Miskell report. Whereas Ms. Duffel and Dr. Zamani have done a statement of evidence. I think that's me. I'll hand back to Mr. McCutcheon.
Thank you, Ms. Stevens. So since notification of the Section 42A report, it has prompted a submitter, Mr. Richard Murcott, number 322, who, among other hearings, made a submission on hearing stream 3 for heritage. The release of this report has prompted him to check in on one of the earlier recommendations that I had made and has asked for an update on that. So right now I wish to just clarify what the recommendation was that I made and what I think should happen with that recommendation at this point. So Mr. Murcott, he sought amendments to the mapping of the extent of the Te Akiwai stream in Thornton, a site and area of significance to Māori. Mr. Murcott's submission was informed by detailed cartographical and archival research of where he considered the extent of that stream should be at a much more granular level than the mapping which informed the proposed and notified version of the plan which was obtained from the Regional Council. I agreed to Mr. Murcott's mapping amendments at my recommendation number 376, subject to the absence of any concern from Mana Whenua. Mana Whenua Taranaki Whānui had given approval to the location of that stream as it was originally notified. My recommendation was intended to act as a prompt for Taranaki Whānui, who were not a further submitter in support or opposition to Mr. Murcott's submission point, to speak at the hearing whether they agreed with my conclusions. That did not happen at the hearing. Subsequently, Mr. Murcott has been to some extensive effort to follow up with Taranaki Whānui as to whether they have any issue with the identification as he proposed. But has not had any success in arranging a meeting or getting any confirmation either way from Taranaki Whānui. Overall, I remain satisfied with the relief sought by Mr. Murcott on the mapped extent of that stream, given that it represents a reasonably small change from the notified extent, and no apparent concerns have been voiced by Taranaki whānui on this matter. So my recommendation is to amend the stream to follow that proposed by Mr. Murcott. That I trust closes the loop on this matter. Otherwise, I have no real introduction to make to this Part 1 wrap-up report, other than I make myself available for questions to yourselves. And I have tried to offer helpful commentary in responding to a number of these submissions, which are sort of PDP adjacent, as it were, and there's no sort of direct relief that can be granted by the plan. I've tried to be quite helpful, and things sort of there might not be any relief that you can grant through this process for some of them, but I intended to be helpful. Thank you.
Just in relation to Mr. Murcott's submission, further issue, if you like. Could I just recap? So he approached Taranaki whānui for their comment. Is that a normal sort of process where submitters would?
I have not heard of it happening to this level of detail, but I felt it only fair to Mr. Murcott that I communicate the efforts he has gone to as of his own initiative, using his own time to follow up on this matter.
No, I'm not being critical of his efforts by any means. I guess I was just trying to understand the process and whether or not the council have made any effort to approach Taranaki whānui for their view.
So I have not personally followed up with Taranaki whānui on this matter. As I had noted, I intended my recommendation to act as a prompt in the hearing so that it were out on the table, as it were, and before yourselves. So it was clear what their view was on this matter. I also am aware that there is some pretty challenging resource, there's a lack of resource at Taranaki whānui at the moment, and it's a difficult and finely balanced decision as to when officers engage with them, given the other substantive issues which mana whenua are currently dealing with. But I have not personally reached out, no.
And so you're saying that the change, if you like, on ground is relatively small.
Correct. So it's moving the mapped extent at the termination point of the Te Akiwai stream by cartographically it might be 20 to 30 odd metres or so. I would have to check, but Mr. Murcott has provided some detailed. He himself works for Land Information New Zealand and has access to a lot of detailed cartographical and archival information about landforms and where features are. And I am not qualified to question the accuracy of that advice, but it did look quite compelling upon my review.
Thank you.
If you don't mind, just to familiarise or refresh my memory, that what's the rules that attach to the mapped extent of that stream? Are they setbacks or what are they?
So the rules are when earthworks or new buildings are being built on top of that mapped extent, and as notified, it's quite a thin line. A resource consent would be required as a restricted discretionary activity. In my Section 42A report for that hearing, I also put forward a recommendation that the panel consider broadening that to reflect that streams actually have more of a width than just a thin line on a map, and I gave a nominal value to put forward for your consideration, but it does have the effect of requiring a resource consent.
Can you recall what that nominal value was?
It was 5 metres. That was my suggestion. And I also, again, hoped that it would prompt conversation from submitters in the hearing, but I don't believe we received any further comments.
And it's just at the terminus of that stream.
Correct.
Yeah.
Yeah.
in changing the map to extent, does it affect any additional properties other than what was shown in the notified version?
So I believe it might affect one or two. The way in which the rules function, and this relates to my concerns about how effective the provisions would be, is that they would only apply if you were doing works directly on top of that line. So it might not be that more property owners in terms of allotments are affected, but where works could occur on that site without resource consent under these rules would change.
Sure.
And as for the terminus, so the terminus is mapped at the 1840s shoreline, which was the mapping approach that Taranaki whānui wished to take for their sites and areas of significance.
Sure. Yeah. Okay. So there's not a centre line with a setback. It's just a thin line.
Correct.
Yeah. Yeah. And you probably covered this, but earlier, presumably was there some scope to make that change? Was it Correct. Murcott himself?
Correct. It was a very clear and informed submission point from Mr. Murcott.
Thanks.
Can I ask, is there a map or something that will show the as notified versus as recommended?
Yes, I can make that available for yourselves. It's also in his submission point.
Are you open to questions from the panel?
I am.
Good.
That one.
Mr. McCutcheon, just one from me. With regards to submissions, Mr. Marriott had asked for the addition of a mandatory design review panel for all inner city developments. In your response, you respond with regards to urban design panel. I'm just wanting to clarify if the request of Mr. Marriott, a design review panel, is limited to urban design, or if you just understood that this was what he was referring to, because we have had other submitters that were saying that in general the design guides, which are linked to that in a certain way, some of them say it's urban design guides, others say it's design guides, but then there is also the question of that some submitters say the design guides have matters in them that should be struck out because they are not urban design related. So I'm a little bit unsure of how far the design guide reaches and how far that panel then in turn that Mr. Marriott is seeking, what the intention really is. Is it a design, overall design, including some architectural elements, including some urban design elements, or is it just a purely urban design?
Certainly. So I don't wish to get into much of the detail of the other Section 42A report and the assorted matters to do with design guides and design panels, but the matter of design panels, urban design review panels, had been considered at length in hearing stream 4 in the city centre zone, as I had understood as a mechanism to have a panel of experts rather than just an urban design officer at the City Council reviewing a resource consent for its compliance with the design guides. So that was an assessment in a sort of a mechanical function or a process of assessing a resource consent, which that was set out for. The design guides themselves do have quite a broad scope, and we'll hear a lot about that this afternoon with Ms. Stevens and her experts. But they are intended to be focused on urban design matters with some, I would say, broader scope around the city outcomes contribution kind of response, which is set out in appendix, a separate appendix as part of the district plan. That's so that the city outcomes contribution is not part of the design guides per se, but is sort of a design, or can be part of a design response. Mr. Marriage's point related to medium density zone MDRS development, so 3x3. Those don't require resource consent, provided that they are designed to meet the permitted activity standards in the district plan. So no, there can't be a design panel intervention for an MDRS development.
And I might, excuse me, I might come back later on to Ms. Stevens and we'll ask the same questions or similar again. Thank you.
For you, Robert. I've just got a generic question. It may be that I just haven't read everything. So is there, for the definitions, nesting tables, general admitted submissions and minute 29 matters, where do I find the amended provisions? It doesn't appear to be in the bundle, but
So I haven't recommended substantial changes to the provisions in the plan. Where I have recommended amendments, so like in response to the City Council submission to add a macron to the word makara, I haven't gone through the entire plan and identified those references. What I suggest is that's something that we can do editorially, because it's largely an editorial change, in reviewing your draft recommendations, and we can pick it up at that stage. But if you would like to receive a copy of every reference, then I can produce that for you. But the changes that I've recommended in this 42 are largely editorial in nature. It's
largely or solely? Are there any substantive, even though there might be minor changes that are not editorial?
So another example is I've recommended we don't use the term lot, we use the term allotment, for example.
Yep.
My view is that's an editorial change. It's not substantive, given that when you dig into the definitions chapter, they're talking about the exact same thing and one's just duplicated. Another example, healthcare facility. The plan uses healthcare facility with a space between health and care in one instance, and it's one whole word in the other.
Yeah, those are not material. It's just that, are there any changes arising out of this report that I've got them in my hand that warrant a track change or some revision amendment?
No.
Okay. So, okay. Second question is, Mr. McCutcheon, did you eventually produce amended provisions for hearing stream 3?
Yes, I did, and those were provided to the hearings administrator for provision to yourselves, but if that hasn't happened, I can follow up on it.
No, well, that's probably more on me than anyone else. You weren't able to do it before you went away, were you?
No, I provided it as soon as I got back, though. Yeah.
Okay. And is that limited to heritage matters, is it, or?
Correct. So that was just in response to the couple of minor tweaks I recommended through my right of reply response. There were very minor matters. I think there was only a couple of words that required amendment.
So long as
you will.
Hunts has got a copy of it. That's the main thing.
I can follow up with the hearings administrators very shortly.
So the reason I asked that is they take the very first matter on definitions, maintenance, repair, which has a direct impact on heritage. When I get So, well, I'm taking from paragraph 66 to 73 that there hasn't been any further change. Is that correct to that definition as a result of this wrap up?
Correct. So the definition of maintenance and repair in the notified plan has about 4 separate components to it for different purposes. We've fiddled quite substantially with the maintenance and repair definition as it relates to historic heritage. In terms of how it relates to infrastructure, I don't propose to address that now.
Going to 9 or whatever.
Correct. Yeah. That's the most appropriate time to address it in the round. So I haven't recommended any change.
Yeah, very comfortable with that. Administratively, where do I go? Where do I go to see the definition of maintenance and repair and attract? Presumably, in terms of the changes you made prior to today.
So that would be in that heritage. The track change document, which I provided after my right reply.
And as you say, that term has application to other matters other than just heritage.
Correct.
Okay. That makes sense.
It's a bit unfortunate, given that the one definition is sort of sliced down the middle for part of an IPI process and then part of a Part 1 process, that we will have the same definition considered twice. Decisions have to be made on one part of it now and then on a second part later. But yeah, compartmentalising it so we're not mucking with the infrastructure bit now, I think it is the right thing to do.
Yes. And my questions are probably arisen because I haven't taken the time to look at that piece of work they've done on the amended provisions and when you got back. So
certainly I'll follow up today.
That was all from me on the generic approach.
Yeah, I've just got one question, and sort of piqued my interest more than anything. Your para up to 282 on page 37, where you talk about let's get Wellington moving, expecting to utilise extensive powers available under the Urban Development Act 2020. I know that's in the future and a future decision to be made, but in terms of the decisions that we make, or the recommendations that we make, would any future decision maker in terms of the Urban Development Act powers have to take into account where the district plan lands in terms of those processes? I know it's a potential big monster out there in terms of the Urban Development Act and what it might do and so forth, but I'm just a little bit unsure about the influence of the PDP in terms of the Urban Development Act and what that might do, whether it would be a matter to be considered, or it could be something which Mr. Wellington might be able to comment on as well. But it certainly piqued my interest in terms of that we're going through a significant process here at the moment, and potentially there's another piece of legislation can come in over the top and potentially produce different outcomes. Have you thought about that at all, or got any comment on that?
I'll start by noting that in this paragraph I talk to the powers under the UDA Act expecting to be utilised, and probably more along the lines of could potentially be utilised, which was where things were at in hearing stream 1. So this perhaps overstates the expectation that those powers will be used. Considering what the relationship is between the UDA and the district plan and how the district plan must be considered, I might have to lean to Mr. Whittington or return to you with some advice on how a district plan is considered in formulating a specified development project as it is. But at a high level, I do understand that SDPs can override or suspend or introduce new district plan provisions, irrespective of what they want, the decisions that you will make today. And I think there is, depending on where Let's Get Wellington Moving as a program and as a project of works ends up, there could be changes to the provisions as recommended by yourselves and determined by council. But I will return to you unless Mr. Whittington has some advice off the top of his head about how a district plan must be considered.
Yeah, I think that is the key point that I certainly in my own mind like some clarity on. Whether the PDP is a factor which must be considered in terms of the process and the outcomes that a process under the Urban Development Act would enable. Something I wouldn't mind knowing a little bit more about.
I'm not seeing in the Urban Development Act anything that says that when determining or when considering a specified development project, Kāinga Order or the minister needs to consider the existing planning framework or the district plan or anything like that. But in practice, I think they necessarily will have to, because the whole point is to determine whether to allow development to proceed as per the district plan's enablement, and whether that's likely to occur based on things like land consolidation, who owns land in the area, what developments are proposed, or whether it's better to create a development project area and then go through another planning process to create a new planning framework for that area and acquire land for the purposes of a project of some sort. So they will be weighing up whether the intended project objectives will be met best by going through the Urban Development Act or leaving it to the status quo effectively. So to some extent it will be relevant, but it doesn't appear to be a sort of a listed mandatory criterion.
Okay, thank you.
Minor points. I found that map in Mr. Murcott's submission at the back end, so you don't have to supply that. So thank you. Just in paragraph 154 of your report, this matter came up in the centres hearing. I believe Ms. Stevens or Ms. Hayes addressed this point where Ms. Rush, her example, and she gave the example of a community composting centre in Cummings Park in Naiho, back of the shops there. So that's the example she was using to want permitted or provided for in the plan. I don't know if that would change your mind or not about that issue.
I think pragmatically what would happen is that if it's just a couple of pallets that are set out to allow people to put food scraps in and turn it over to compost, then that would be looked favourably upon, and it wouldn't be addressed as an industrial activity and enforced as such. But if it were a significant facility for the receipt of composted waste and like a much more industrial utilitarian scale building that was required to do that, then certainly that would be captured as an industrial activity. But so one way you could address that would be like permitting composting in certain zones. But I think that's already addressed under the community gardens rules that are in the residential zones. That would be captured under that anyway. So I'm not sure that there is a regulatory misalignment or an issue where you're capturing small scale composting of domestic organic waste in the plan as a discretionary or non-complying activity.
Another question, just a few pages on, paragraph 178, is around the sort of emergency facilities that Mount Cook Mobilised were seeking. I suppose the question arose when I read that is, does the district plan or proposed district plan disable these things to occur? Does it stop them from occurring?
So water tanks, above ground tanks, would be treated as buildings per the definition under the national planning standards. So there would be some regulation of a water tank for the application of site coverage rules or building coverage rules, depending on the zone, if that's a relevant consideration. Otherwise, I would be surprised if these structures or these buildings would trigger any height in relation to boundary rules, considering the level of development which is being recommended by officers and is even in the notified proposed district plan and the standards which apply to them. My view is that while emergency preparedness is a hugely valuable thing to do and something that I place a lot of value on myself, I don't see that there's a direct connection that's needed in the district plan to require the examples that have been set out by the submitter, Mount Cook Mobilised, within the framework of the plan.
Thank you. I'm grateful for the writing style guide that you provided. I was interested though, this is on page 49. I mean, it all sort of made sense to me in a planning perspective, but the discretionary category on page 49 uses avoid as a descriptive term, and I was interested in the reasoning for that.
One of the examples of where that's used is for the demolition of a heritage building. In coming to the recommendation to use the term avoid, given I was the reporting officer for that topic, there was considerable debate and discussion around whether avoid should only be used for a non-complying activity and what the net benefit for the example of total demolition of a heritage building would be if the same policy were used in a non-complying activity status sense. And where we got to was that there was actually not a lot of difference or no net benefit. So the term avoid, as we ended up using in a discretionary sense, still allowed a high level of direction or requiring a high test that avoidance should be required, subject to a range of certain offsets or meeting criteria, but still allowed for the consideration of positive effects, which you can't do to the same extent in a non-complying activity status. So I think it certainly is possible to use the term avoid for a discretionary or non-complying rule, but the difference comes down to that the assessment of that gateway test and the consideration of positive effects. So if there are the potential for positive effects to come out of that activity, it would be appropriate to use a directive avoid and a discretionary activity status.
Yeah, but the guidance doesn't actually explain that sort of part of the equation in terms of describing discretionary activity, basically. That positive outcomes should be, I would have thought, probably put into the language of whatever it is the provision relates to. Do you understand what I mean?
Within the policy itself, right.
To just expand on that, avoid doesn't necessarily mean avoid. It means avoid if, taking into account positive outcomes. Something like that.
Robert, can I follow up on that? So I'm particularly interested in this one, Mr. McCutcheon. I'm not sure I don't remember the policy offhand. We discussed it a lot in hearing stream 3, but
the numbers have changed quite a bit.
Yeah,
we know the one we're talking about though.
10 or 17 rings a bell.
13.
13, yeah, okay. But my understanding was that they were almost qualified in a lower queue avoidance policies because they always had the word unless it can be demonstrated that Wasn't avoidance per se, was it?
No, it wasn't avoidance per se. It was avoidance with a very strong and directive requirement to show that you've exhausted all other options and all other reasonable alternatives to retain a heritage building.
So I think there were four or five scenarios where
Correct.
there might be a consenting pathway.
Correct.
And you'd come back on scenario one, I think, which related to the repair and maintenance component about both historical and going forward.
Correct.
Yes. Presumably, if the policy was avoid per se, you'd have no problem in recommending a non-complying activity status.
Absolutely. If the policy were as straightforward as avoid the total demolition of heritage buildings, then I could see how that could have a non-complying activity status. Whether I think that's the appropriate planning response is a different matter.
But that wasn't the question.
Yeah.
No.
Yeah.
Yes. The chair's question though about the positive effects, I hadn't read that into hearing stream 3 that was the intention behind the policy.
It's not the direct intention, but behind why I've used a discretionary activity status for a heritage building, but mechanically it's a matter that could be considered under the Act rather than the gateway test, which is looking at not contrary to the policies or the effects test of being no more than minor. So in the case of the total demolition of a heritage building, the effects are probably always going to be more than minor. Which is why I didn't recommend a non-complying activity status, because I thought it was kind of a bit of a nonsense anyway.
That's right. It's always going to come back to the policy, isn't it?
Exactly. Yeah.
No one's going to say that the loss of heritage fabric is in
exactly
the less than minor effect.
Mm.
Is there any need to be more explicit in terms of the positive effects, in terms of the policy setting? And whether the scope to do so is another question, but put that to one side.
I think it within the framework of the plan, it's probably sufficiently addressed, given that when you are triggering a discretionary or non-complying activity status, you're also then opening up the consideration of the strategic objectives of the plan, and they are pitched in a way which is looking at they're quite future focused, and they do take a say an aspirational or a high level focus of where the plan seeks the city develop and in what ways. So I think it probably is sufficiently addressed, and that you're able to broaden consideration from just a directive policy.
Can you remind me? It's not the urban inform and development ones. There were specific heritage ones.
There are specific historic heritage and sites and areas of significance to Māori is a standalone chapter within that strategic objective. Strategic directives chapter.
Yes. Probably a good opportunity for the panel to do a bottom-up test. I mean, given that strategic objectives are largely top-down.
Correct. Yeah.
In light of this language, just to see that have you done that?
It will have been done when the plan was notified, and certainly as the reporting officer, I was looking at the relationship between what had been recommended in stream 1 and my recommendations in stream 3. But it's a bit awkward in whether those strategic directives, strategic objectives are drafted first or the lower order provisions. But there's certainly, I agree with you, Commissioner, there needs to be a high level of relationship, or they need to speak to one another, essentially.
I call that ground truthing in a sense, but sometimes it provides with useful nuances to the strategic objectives that perhaps weren't always considered when you're setting those policy frameworks to give effect to the higher order.
I agree.
Yeah. Robert, I had some questions on I just want to spend the next sort of 2 or 3, 5 minutes maybe just on this policy language, and from 2 aspects, Mr. McCutcheon. One is the correlation between policy direction and activity status, which was sort of just touched on, but also whether there's any gap analysis, and particularly relating to inclusive versus exceptional drafting. exceptions drafting, if you like. On the first matter, the question I've got is that for all activities that are subject to an enable policy direction, is there always a corresponding permitted activity status in the rules, or does it map between permitted and controlled and restricted discretionary?
So
And these are plan wiring type issues. Yeah.
Precisely. So in reviewing a number of recommended chapters to date and the notified plan, in terms of the word enable, I found that used for only permitted and controlled activity status rules.
That then. Yep. And was that intentional?
That was intentional. So at the start of this section, section 11 of the 42A report, I noted how the design guide, or the drafting style guide, had been intended to be used as a bit of a Bible for plan drafters, but unfortunately that's not always how it works. And there had been some variance from it in the resulting notified chapters, but these were the common terms that had been tagged to specific activity statuses, with some sort of outliers when it came to things like infrastructure, where there's a bespoke regulatory regime.
Sure. I guess why I'm asking this, the answers that you're giving are important. But it's more important that I'm hearing that you've done the exercise.
I have.
Yeah. Okay. I'll carry on with the questions, but that might get much quicker. So the converse is that for all activities subject to an only allow where direction, is the corresponding activity status always discretionary?
In the table I've set out here, it could be restricted discretionary, as in HHP 15 or NHP 5, or it could be fully discretionary.
Okay. And presume. Okay.
And what that reflects is that there is a combination of this scenario-based drafting approach where it's very certain, it's reasonably certain that something will be appropriate where one or two scenarios take place, and you can limit discretion to those scenarios. Whereas if you want to consider a broader range of effects or a broader range of circumstances, that only allow would be also applicable for a discretionary activity status, because it hasn't taken that scenario based but a overall judgment kind of approach to decision making.
Okay, thank you. I'll move on quickly because I'm conscious of time. Are you, as a sort of the lead on this, where have officer recommendations response to submissions always maintained that approach of both the enable and the only allow? Has there been any departures?
From what I saw reviewing essentially all of the recommended chapters back to the panel, I didn't see any circumstances where enable was used for a restricted discretionary or a discretionary activity status, or the inverse, that only allow was used for controlled or permitted. There's quite a clear distinction and divide between those terms, such that I'd be satisfied they haven't been inadvertently used, or a drafter thought that it was appropriate to do so.
Sure. Okay, and just lastly, and this is sort of under the heading of the inclusive versus the exceptions drafting, and it draws on some of these things again. If the direction is to provide for activities where effects are avoided, subject to whatever, what direction is there for proposals that will result in those effects occurring? Is it clear? Is there any sort of threshold that minor impacts might be acceptable versus more significant impacts? Is that something that the policies try to grapple with or not?
Precisely. So the policies would grapple with the relative level of effect that was acceptable in providing for or allowing that activity. So as an example, repositioning of a heritage building on its site,
Yes.
or relocating one within a heritage area. That was one of the very matters that I believe I closed the loop on in my right of reply, when there was no level of effect that was identified as being acceptable in undertaking those activities. So where it just said where there are, it's okay where heritage values are, not changed. Actually, what I think would be more appropriate would be where there are no significant adverse effects on those values. So the policy wording and the detail of the policy will say what that relative level of effect is.
And it might use the term significant.
It might use the term significant, or it might say where there are no significant, or it might say, those would be the two most common examples.
Okay, well, I'll close it there. As I said, the answers are important, but the fact that you and your team have gone through the exercises of more utility to know that. But thank you for that. Thanks, Robert.
Any other questions from you?
One, thank you. Just in relation to Greater Wellington's submission, this is to your paragraph 201. And when I read this submission point as you've written it, they're talking about the use of Māori data and the interpretation of that data. And then I look at your response, and you've included, Mātauranga Māori as a component of best available information. And I might be my reading, because I'm reading your summary of their submission rather than the full submission. But I wonder if there's a slight difference in what they are seeking is perhaps, more of how that data is managed, stored, interpreted, or protected in terms of ensuring cultural safety and ownership of that data. I mean, I might be quite off track, but when I looked at that and I thought back to Hearing Stream 1 with the inclusion of Mātauranga Māori, I'm not disputing that, but I just wonder if there's more about the actual safety of that data once it's outside of a cultural realm, if you like.
Certainly, I agree. Your interpretation would be much broader in scope than how I've responded to it in the Section 42A report and in Hearing Stream 1 as well. I'm happy to do some further work and come back in reply on this matter if you would like.
That would be helpful, yeah. Sure. Thank you.
Any further questions? I'm just aware of the time too. We are due to break at 10:40, but I'm just thinking we have a clearer break now, and then start with design guides after that break. If that's just all right.
I have answers to the questions if you want to do them now.
Yes, certainly.
So, two questions. The first was, what happens when you release your report? And the answer is that the council must decide whether to accept or reject each recommendation. I suppose depending on what it does, it may provide an alternative recommendation. So it may, rather than just accept, rather than just reject a recommended provision, it might reject that and provide a different one rather than simply deleting it. It must refer to the minister each rejected recommendation with reasons for rejecting it. And interestingly, it may seek clarification from you about the scope or intent of any particular recommendations, so that it may well be that that affects the question whether you're functus officio. I was going to say it may be that you retain power, but only for some limited purposes. It may be wider. I don't know that we need to address that now, or that I can.
So do you mean the minister?
No, the council. So the council has the power to come to you and say, we don't quite understand this recommendation, or could you explain what you meant by this particular recommendation, or something like that.
What's the precise wording of that? Just out of
Precise wording out of interest.
When making decisions under subclause 1, which is the accept or reject, the specified territorial authority may seek clarification from the independent hearings panel on a recommendation in order to assist the specified territorial authority to make a decision under subclause 1.
Yes. I presume that could be during the matter being debated at the council. It could be following that in a more formal sense.
I think it could happen in various different ways. It may be that as the officers prepare the report that presents your report to them, it may be apparent that there's a recommendation that has a missing not, for example,
Sure.
and they want to clarify whether you intended to say X or actually not X.
Sure.
It could be that in the hearing debate, as you say, the councillors are wondering about particular reasons. I don't know whether that would require them to then effectively adjourn that debate while you know, or whether you're asked to, or the chairs perhaps are asked to come and present to the council. I can't work out.
Someone with a greater pay grade than me will probably answer that.
Well, I imagine that the council will learn from the way that other councils have done it, such as Hutt City and Porirua will have gone through it by that stage too. The second one is on the OLS. And my answer is no. I don't agree with Kāinga Order's position. I don't think that it leaves a question as to whether the council has complied with its obligations or not. And the reason for that is effectively a tracing through of the legislative provisions that relate to qualifying matters. Section 77G says that the council must incorporate the NDRS in every relevant residential zone, and effect policy 3 in every residential zone in the urban environment. And 77G6 says that the council may make the NDRS or policy 3 provisions less enabling only if authorised under section 77I. That then takes you to section 77I, which says that the council can only make modifications to the extent necessary to accommodate a qualifying matter that is present. And then there are A to J listed matters that qualify to allow modification if the council then chooses to go through the establishment process. If you don't modify the NDRS for the building heights and densities under policy 3, then there is no qualifying matter. No qualifying matter assessment is required. And perhaps Mr. McCutcheon can confirm, but I'm not aware of any location in the city where the council has modified the NDRS application or policy 3 application to account for the existence of the OLS designation. And this is a question that came up actually in hearing 1 when we were discussing the council's approach to modification or to qualifying matters in general, and whether a qualifying matter analysis was required for things that might affect a particular site in practice. The example we talked about at the time, although it's not it's a theoretical one because of the way this plan deals with sites of indigenous vegetation, significant indigenous vegetation, is let's say a site is 50% covered, 60% covered with indigenous vegetation, and you might need a resource consent to clear enough of that vegetation in order to build to the MDRS standards. In that event, the council's position would be that you don't need it's not a qualifying matter assessment simply because a particular site happens to have a practical issue in achieving heights and densities that are permitted under the MDRS or Policy 3. They are permitted activities. The fact that there is a separate requirement for some sites, if they protrude through the OLS, to get consent of a designating acquiring authority, does not affect whether it's whether the council has applied a qualifying matter. So that's my assessment of the council's obligations and whether it's complied or not with sections 77I, etc.
Because one of the matters under 77I is designations.
Yes. So you could, for example, say, because of this designation, we're going to restrict height to 10 metres, 9 metres. We're going to restrict number of dwellings permitted to 2 instead of 3. Or we're going to permit no further development in this area because it's not appropriate in light of this designation because of reverse sensitivity effects, for example. But in relation to the OLS, the council has not done that.
At the risk of raising the view shafts topic, you raised the question of you're not aware of any examples of changing the MDRS or Policy 3 that doesn't relate to
on account of the OLS.
Yeah, okay. What about across the board? Are there any examples in the plan where council have changed density or in height for reasons other than a qualifying matter?
I need to talk to Mr. McCutcheon about that too. I don't think so. There are instances of changing heights and densities, such as around heritage buildings in the city centre zone, for example, across the city. So the existence of a heritage item is a qualifying matter that the council has applied and gone through its assessment for. The same occurs for the character areas,
Yes.
character precincts.
Yep, familiar with that. What about view shafts?
Perhaps I can talk with Ms. Stevens, and I'm trying to work out exactly where there's the internet.
And Stevens, the answer might be the difference between what was notified and what's being recommended, particularly in relation to the MDRS rules, where the exceptions apply.
Yeah, I think with regard to view shafts, and this is in my report or further memo response to Mr. Winchester last week, I think it's notified the provisions had a greater effect in terms of a qualifying matter impact upon properties within the view shafts, but I sought to correct that through my latest changes in terms of allowing MDRS to be enabled within those properties to better give effect to the MDRS and MPS.
Yes. What about the that correction applied to both the MRZ and the HRZ, didn't it?
Yep, for both in terms of being a developed MDRS. In terms of the HRZ, it's more enabling because of where it's located in terms of view shafts.
Yes. So the correction had the most grunt on the MRZ, but essentially, as I understood it, the MRZ rules would prevail, notwithstanding any intrusion. That was it.
Correct, yes. So the main area of focus in terms of managing height for avoiding intrusion into the base of view shafts is largely in Kelburn because of just topography and the heights, but that still allows 11 metres, so MDRS, then just manages that 14 metres, so MRZ S1, but still allows HRZ maximum height limits and also within the rental bay underneath view shaft 15 allows the heights up to the rental bay height precinct.
Yep, I haven't read that latest response yet, but I'm sure it's all in there.
Yeah, and I just note as well the MRZ areas kind of in the near the focal areas. It's enabling of development given the change to Kelburn.
So my take on that, Mr. Whittington, is that for view shafts, when the plan was notified, it potentially had an impact on height intensity in terms of policy 3 and MDRS, wasn't explicitly qualified.
That's right, and I think wasn't appreciated by the officers at the time, and having identified issues with the view shaft provisions, and also that actually it did have that effect. The changes that have been recommended mean that actually it is not a qualifying matter.
That's right.
I might just talk over the break with Ms. Stevens about that, because I thought there might be a small site in Kelburn where that's not the case.
And that might be the case, and the question is that arises is whether that needs to be qualified in any way.
Yes, and if I'm right about that, it does. But
and whether Ms. Stevens might have done that already in terms of the supplementary response to the Winchester opinion.
That's right. Well, we
So sorry, just note now, it's not a qualifying matter because the small area of intrusion into the 11 metre height limit. So there's everywhere can do 11 metres and do MDRS with the view shaft provisions as they're right now, as per my latest memo. So there's no qualifying matter.
Good to hear. Sorry for taking us off track there. And coffee.
Thank you, Mr. Whittington. They were useful points for us to consider. Yeah, thank you for that. Okay, with the time being 10:36, I'll adjourn the hearing until 11 o'clock. Thank you very much.
Sorry.
Good morning, everybody. The wrap-up hearing for the IPI provisions is resumed. And I believe we're being led by Ms. Stevens.
Good morning, Commissioners. If it's okay with you, I'd like to just do a brief overview of kind of the process of design guides have been through in the last 4 months, just as a bit of a step through since hearing stream 2, and then I'm open to any questions you have. But actually, sorry, I'll take one step back. Before I do that, I might just hand over to my experts to briefly introduce themselves first, if that's okay. So I'll pass to Mr. Banks.
Kia ora, Commissioners. So, my name's Andrew Banks. I'm a planner at Bottom School. I'm part of the independent review team that was engaged by the council to essentially facilitate the expert conferencing on the design guides and undertake the review of the design guides in light of the outcomes of that conferencing. So I'm not here to present any evidence, but I am available to answer questions if you have them about the methodology that was used and any of the content of the report that we prepared, which is appended to Ms. Stevens' Section 42A report.
Might pass over to Ms. Duffel to introduce herself.
Kia ora. My name is Sarah Duffel. I'm Senior Design Review Advisor in the Urban Design team. My role in this has been to provide assessment of the submissions on the subdivision design guide.
Kia ora, Commissioners. My name is Farzad Zamani. I'm the ex-urban design manager of Wellington City Council and heavily involved in the design guides and providing advice to Mrs. Stevens on a number of standards. Also be involved in the conferencing process for the review of the design guides with Mr. Banks, and that's it. That's me. Thank you.
Thank you. So in hearing stream 2, Mr. Patterson included within his Section 42A report, Part 6, which looked at the residential design guide, the Papakainga design guide, and the design guide introduction document. So some amendments were made to the residential design guide, and then it was recommended no change to the Papakainga design guide, and that the design guide introduction document was also retained. So then in minute 15, the panel directed that the structure and content of the residential design guide would require further work, and directed the urban design experts to undertake conferencing in relation to the structure and content of the residential design guide. It also identified that if necessary, the Centres and Mixed Use Design Guide should also be reviewed as part of the same process. So then in minute 23 and 24, so minute 23 from the panel directed that the Heritage Design Guide be included in this review process. And then minute 24 directed that the Subdivision Design Guide be included in the review process. And that was particularly in terms of any structural changes that flowed on from the Residential Design Guide and Centres and Mixed Use Design Guide for those two in particular. So just to note that that didn't relate to content beyond anything that was within the scope of the submissions. So then turning to the expert conferencing. So Bottom School, so Mr. Banks was engaged to facilitate conferencing, and then urban design experts on behalf of Wellington City Council, Mackinac Urban, Willis Bond, the Retirement Village Association, and Ryman Healthcare, and also Kainga Ora participate in the conferencing. So Dr. Zamani, Mr. Ray, Mr. Owen, Mr. McIndoe, Mr. Burns, and Ms. Skidmore. So I attended the conferencing just as an observer and to provide any clarity about policy if there were any questions. So as part of Bottom School's review, in the first conferencing session, it identified with the experts common themes and areas of agreement and established a set of principles for the review of the guides. The purpose of doing so was to provide a clear basis for the review of the guides. And this review then entailed determining the principles of the review, undertaking a review of the Residential Design Guide and the Centres and Mixed Use Design Guide, and then consequently the Heritage and Subdivision Design Guide. So I won't go into the principles, but I'll just say that the themes of these principles focused on providing clear guidance for users, ensuring that the guidelines were different from rules, for example, ensuring the guides were usable, so that they were relevant, accessible and functional, and ensuring the guides were focused with clear scope and were consistent, for example. So the joint witness statement of the urban design experts identified the following issues. So the relationship of the design guides to the district plan objectives and policies, duplication and overlap of the design guides, the need to remove the point system and sequentially number each guide. The language was of concern in terms of what was adopted, a need for more directive language, the need to put the guidelines under their respective outcomes, avoiding repetition through reducing the scale of guidelines, and with enhanced language and priorities. So then the Boffin-Miskell report, as Mr. Banks has noted, undertook on council's behalf a review of the design guides in light of the submissions and evidence presented. It focused on recommending to council changes to the structure and content of the guides in light of their review and the outcomes of the expert conferencing. I won't go into the full scale of changes, but just to note some high level ones that came through and agreed to by the joint witness statement. So splitting the design guides so that the residential design guide only applies to development in the residential zones, and that the centres and mixed use design guide only applies to development in the centres, mixed use, commercial and some special purpose zones, for example, the hospital, tertiary and the waterfront zone. So removal of the point rating system from the guides, and then restructuring the guides so that the sections focused on the street and public realm, the neighbouring sites and the internal site amenity. And then one other change was the removal of references to other regulatory requirements, for example, building code, where things are addressed elsewhere, such as provisions in the plan and building code, for example. And then the last key change being a two-tier language system. So a directive approach in terms of language like provide, reduce, for example, versus a consider approach in terms of, for example, consider locating at X. So then jumping to my section 42A recommendations. The design guide, I recommend it continue to be a statutory component of the district plan. I recommended to adopt the residential design guide, subdivision design guide, centres of mixed use and heritage design guide as recommended by Boffin-Miskell in their appendices, which reflects the agreed outcomes of the joint witness statement. And then again, agreed on that spatial separation of the residential and centres and mixed use design guide. In terms of city outcome contribution, no changes from what I recommended as officer in the hearing stream 4. And I also recommended in my section 42A that the introduction guide be adopted as per the Boffin-Miskell recommendations, and that the policy references be updated to align with the notified PDP wording in terms of fulfilling the intent of the design guides. And lastly, just noting on key changes in my rebuttal evidence. So I recommended, upon reflecting on submitted expert evidence, that the design guide introduction document either be retained as a non-statutory context document or deleted, or where a change has been sought, for example, grammar fix, I've agreed to that through submitted evidence, or whether a change was needed to reflect the agreed outcomes of the joint witness statement. I've not agreed to any other change where it was only sought by one submitter or there wasn't consensus or it opposed what was agreed in the joint witness statement. And the last change being that just updating the introduction of the residential design guide and the centres of mixed use design guide to speak to this two-tier system in terms of directive versus consider. A note that no amendments were recommended to the urban design panel method. It just spoke to that in terms of the terms of reference being agreed in time when the panel is established. Only one minor typo change to Appendix 16 for COC when I was addressing Mr. Hill's concerns. And I note that my further memo in response to Mr. Winchester's city outcome contribution legal opinion will be made available tomorrow. And then I just want to recap into the city outcome that in my writer reply for hearing stream 4, I removed the mandatory notification requirement. And I also removed city outcome contribution from applying to the high density zone and the neighbourhood centre zone, and provided more detail how city outcome contribution could be achieved in terms of the point system in Appendix 16. End of my notes. Happy to take any questions you have.
Stevens. We've had some discussion among the panel about how best to approach this. I think by way of a starter for 10, I'm wondering if you could, just for the benefit of the whole panel, take us through the mechanics of the design guides, how they will work in practice. And if there's any differences between the zones, for instance, the differences between new buildings versus alts and alterations and those sorts of considerations, could you just perhaps lead us just to get us into the topic?
And if it helps, should we have the track change amendments in front of us? Would that?
Yeah, I think that would be useful. Probably the latest ones being my rebuttal changes, if you have them in front of you. Otherwise, just minor changes there. So either that or from Boffa School Review. Yeah,
but there's no track change version in the bundle that we got on this here.
Oh, okay. And Mr. Banks can correct me if I'm wrong.
About the rules.
Oh, the rules. There's no amendments to the rules in terms of track changes. It's just the policy wording.
Yeah. So what the chair's asking is we want to know for each zone what the hook is for requiring consent. So is it non-compliance with standards and alts and adds and new builds as an entry level?
Yep.
And how does that differ between each zone?
Yep, I can step you through that.
Yes.
So in terms of, I guess, starting with the policy hook, the hook sits within the design quality and sorry.
Can you start with the consent hook?
Oh, yeah, sure. So the consent hook is in both the additions and alterations rule hooks within the restricted discretionary activity rule.
Is it for residential or for all zones?
This is for all zones which the design guides apply to.
So residential and centres of mixed use zones, for example.
Yes, I note that as a matter of discretion, the hook is essentially a link back to the policy that fulfills the intent of the design guide. So that policy reference and by way of a hook to the design guide sits within the construction and also additions and alterations rule framework. So the matters of discretion in terms of hooking back to the rules. The key change, as I mentioned, is that in the notified plans of the city centre, for example, it had a hook to, well, the rule framework actually had a matter of discretion that explicitly referenced the design guides, but a change was made in hearing stream 4 in particular to change that from a matter of discretion hook to the policy reference. And that was to align with recommendations for the high density zone that Mr. Patterson had. So alignment across the plan to be consistent. In terms of, so the city centre, for example, the focused on the centres of mixed use design guide in terms of that hook for the quality design outcome policy for additions and alterations in construction. But then there was also a policy reference with regard to things like internal amenity, for example, or building conversion, that hook to the residential design guide. For clarity in terms of the review process, it was agreed by the experts that it was better to separate the focus so that it was cleaner in terms of for the centres and mixed use zones and the 3 special purpose zones I mentioned, that they just focus on the centres and mixed use design guide and that there's applicable guidelines within that. Whereas for the residential zones, it just focuses on the residential design guide. So that's just a separation rather than overlap, because that was one of the concerns. So the hook there is in the matter discretion, adds and alts and construction. That hooks to the policy reference, which then gives effect to the design guides.
Just for my own clarity, so if you're looking at, say, city centre zone, the preferred council position in terms of the policy, like P9, I think it is, which is the one which is about quality design, is as per your recommendation. Correct. For hearing stream 4. And there's no other changes as a result.
I'll correct that. It's per I think it's Appendix E of my Section 42A report for this wrap-up hearing. So apologies for that. That's the latest policy wording.
Appendix E.
Yes, I believe it's Appendix E. Yeah, so Appendix A for the Part 2, Section 42A. Okay. And that covers all the changes to the policy that was needed. Yeah.
So, okay, so we've got the track provisions for the commercial mixed use, but we don't have them for the residential because, do we? As part of this bundle.
So not actually, 1 second.
Oh, it's commercial and mixed use, yeah.
Oh, sorry, yes. Yeah, it doesn't apply for the residential because I think the policy didn't need to be updated. Yeah, okay. That's correct. So it's just a centres of mixed use zone.
So can I just ask you some questions? I think I understand, but let's just deal with the residential zone first of all. if there's non-compliance with bulk and location standards, setbacks, heights, that sort of thing, in the MRZ and the HRZ, does that trigger an assessment? Presumably those the exceedances trigger to a restricted discretionary, presumably, do they? As a
Yeah.
general rule.
In terms of the rule, yeah, I
Yeah.
think I'm correct for residential in saying the restricted discretionary, and then that assessment brings in the design guide.
Yeah, that was my question. So,
Yeah.
okay, as a matter of discretion.
I believe it should be through the policy hook again. I can double check that.
Okay, so that's important for my understanding.
Yeah,
So
yeah. So
that's where having the rules in front of me would have been useful.
Yeah. Okay. So the residential design zones, just in terms of that design guide hook, were drafted slightly differently to what was notified for the centres and mixed use zone. But that hook is to the design guide is within the policy, and then again, matter discretion links to that policy.
Yes, and what can you recall what the wording of the matter of discretion is that provides that link to the policy?
I can actually just pull up Mr. Patterson's. Sorry.
I mean, can we get that on the screen? Can we share this on the screen? Yeah. Yeah.
I've got it on my screen.
Yeah.
In the hearing stream too, it should be Mr. Patterson's appendix A for medium density and high density.
It's the commercial.
So I just have it's a policy. Sorry, just getting to the rules. So P6. High density as well. Yep.
Sorry about this, but I think it's on visual person.
No, I appreciate it.
Yeah.
Yep. So I have here, for example, so just looking at the construction rules, so HRZR 17. The hook is a reference, so similar to what's it says the matters in the HRZ P6. So that's where the design guide link is.
Okay.
And P8 for additions and alterations to multi-unit housing. So I think the intent across the course of the streams has been that consistency of language in terms of that matter discretion reference to the policy and the policy wording as well.
Whose is that?
It's this laptop one.
Good.
No one I can see. So where should we look, Ms. Stevens? You see that?
Yep. So, for example, in the rule, I'm on HRZ. Are you on HRZ?
Medium density.
Oh, that's okay. It should be equivalent.
Let's start with medium.
I'll bring up the medium. High density zone open.
Can you make that a little bit larger, Robert?
I can give it a go.
If you collapse the welcome to Acrobat thing.
Yeah. So, for example, I'm on.
Still need Lindsay and I still need at
Yeah,
our age.
so it's, I'll try and get it on the screen. So
Yeah, that's better.
this is from hearing stream 2, right?
So I have Appendix A open from the 42 because I don't believe that there's, as part of the right reply, there wasn't a clean new chapter. But I don't believe that wording has changed, but I can confirm that in writing, or I can check with Mr. Patterson. So, yep, so MRZ, I have. Oh, you're now on HRZ. Okay, I'll jump back. So, for example, HRZ 17. Construction of any, for that one, for example, of any other building or structure.
Yeah, just slow down till we've got it on the screen.
Sure.
Instructions, okay.
Yep.
You've got it, Rob. You just gone past it.
Yep.
Go back to the beginning of the rule. So any other building or structure, including additions and alterations,
And-
permitted so long as you comply. So, and these are all standards such as height, setbacks, those sort of
Yep.
things.
Correct.
And where you don't comply, where you comply with them, the design guide's not triggered.
Correct.
It's
Correct.
permitted activity.
Yep. And then in terms of number 2, so sorry, HR 17.2, where it kicks you into the restricted discretionary, the hook there is
So where any of those requirements are not achieved, the matters discretion are.
yeah. So then number 3 in particular, the matters in HSZ P6
Okay.
references. So P6 then references the residential design guide.
Okay, so that's P6 and P6. Okay, so P6 generally and P8
And-
for multi-unit housing. Is that the way?
Yeah.
That's the intention?
Yeah, so P8 relates to residential buildings and structures. And actually, no, sorry, apologies. It's just P6 that has the design guide reference. And then P7 is for retirement villages.
What's the reference to P8 and clause 3?
P8 talks to, I guess, in terms of development of buildings and additions and alterations, things around providing healthy, safe and accessible living environments, the built environment anticipated.
So does P8 reference the design guide or not?
P8 does not reference the design guide.
Okay, and that was the intention?
Correct, I believe. Yep. So there's only generally, and I'm thinking of city centre zone, for example, there is largely, actually, so for city centre zone, there's 2 examples of connections in policy to the design guides. So you have your quality design type outcome policy, and then you have a focus on residential amenity, which talks to the building conversion and those focuses on things like minimum unit size. That also hooks back to the design guide.
Okay. So that's what you call the default activity for non-compliance with standards, and that's in the high density. Presume it's the same in the medium.
Yes, that's carried across. Yep.
Is there any straight entry for any buildings in the residential zone to this as an entry level for any activity?
In terms of requiring design guide assessment?
Oh, no, is there any? Well, sorry, we'll explain the question better. Do the rules for any activity in either medium or high have an entry level of restricted discretionary, regardless of design guide?
I must admit, I'll just have to check that one and come back to you, only because my focus has been on the centres and mixed use zone, but I can come back to you.
And the subsequent question is, if they do, is there then reference to the design guide? Because it strikes me there could be 2 ways you get to the design guide in a residential zone. One is through non-compliance with standards, which we've just discussed in H17. The other is through, I don't know, for 4 units or more as a multi-unit. Does that start as this?
Yeah, so actually, sorry, I correct myself there. So for example, application for multi-unit housing or retirement village straight away as a restricted discretionary. So apologies, yes. Restricted discretionary activity, and then that hook there is to the policies which have that connection to the design guide. So
Gotcha. So that's the difference between 3 and 4 then.
Yes, correct, in terms of that separation. I do note that, so I think I directed you to HRZ 17, but HRZ 14, for example, Rule 14, sorry, is construction of buildings or structures for multi-unit housing or retirement villages.
As a restricted discretionary.
Yeah, restricted discretionary, specific to that rule, whereas I think the other rule that I directed you to was for any other situations.
Yeah, that's really useful. Thanks, Ms. Stevens. Could we have a look at P6, 7 and 8 now, just to close that loop as to? And it's just for those matters of discretion just refer to the policy. There's no words in front of it like consistency with the policy. It just refers to the policy, doesn't it?
Just pull it up in front of me.
Under subclauses 3 and 4.
Yes, I believe it should be that the matters in the policy is essentially the wording beforehand. Yeah.
Okay, so.
And that was a drafting approach in terms of consistency, directly hooking back to policies in the rule framework itself.
Yes. So P6 was the key one, wasn't it?
P6, and then there's also P7. Yep, in terms of retirement villages, there's references to fulfilling the intent of the design guides.
And okay, that's the wording, is it fulfilling the intent?
Correct, yep. And that's now, based on my latest recommendations, consistent also with the centres and mixed use zones, or generally the wording for consistency across the plan.
Robert, could you bring P6 onto the screen? Okay, got it. So was that always there's no red lining, no colour there, was that clause 1 of P6, was that the notified?
It's a notified version,
okay,
yeah.
good.
So I'd say it's probably, in terms of changes, it's more likely to the centres and mixed use design, centres and mixed use zone references to be in alignment with the residential zone. So that's why you probably see more red pen on those policies.
Okay, that's good. So, sorry, this is... So, okay, when we get to a situation where we don't, for adds and alts and new buildings where you don't comply with the standards, go to the matter of discretion. The matter of discretion refers to P6, and that's, but that says provide for that P6, because in the matter of discretion there was reference to both in clause 3 or 4, 2 or 3. It referred to both P6 and P8, and P8 was tagged on multi-unit housing, I thought.
So P8.
Can you just read the wording out of that clause in the matter of discretion?
Oh, sure. Yep.
Is it 2 or 3? I can't remember. Not the one that deals with retirement villages, the one above it.
So.
And H17.
Yeah. So for example, the construction of buildings or structures for multi-unit housing. Just reading that matter of discretion. So the matters reference other policies, but in the matters in HZ P2, P3, P5, P6.
No, that's not the one I was thinking of. On 817.
Oh, yep, sure, I can jump down to that. So then 17 says the matters in HZ P6 and P8 for additions and alterations to multi-unit housing.
Yeah, that's the issue. That's why I asked you the question: is the reference to P6?
In terms of the double handling, or
yeah, well, if you look at P6, it talks about multi-unit housing, but you told me that P8 was the one that was in that matter of discretion. P8 is linked to multi-unit housing.
So P6, and sorry about confusion. So P6 is multi-unit housing. P8 more generally is a kind of quality design outcome type policy that applies more generally to development.
Can you read that clause in P17, sorry. The
R16, R17, sorry.
R17.
Too many numbers running around. Yep.
As recommended.
Sure. So as per the section.
Read the chapeau and then go to clause 3 or 4.
Sure. Oh, I see. Yeah. Matters of discretion are the matters in HRZ P6 and P8 for additions and alterations for multi-unit. So sorry, yes, you're right. It seems to just focus on the additions and alterations for multi-unit.
Yes.
I see.
Whereas, I mean, the P8 talks about the additions for multi-unit, but P6 is dealing with multi-unit housing. So
it seems to be that the construction element is within P6, but also P8 in terms of additions and alterations that apply. So yes, thank you for that clarity.
Sorry,
that's that separation. No, that makes sense. And yeah, sorry, I'm familiarising myself with the residential zones being more centres and mixed use.
Yeah, I mean, there's a simple fix there. I mean, you either you separate them out, or you align the multi-unit housing to P6.
Some more clarity on that matters of discretion.
Yeah. Okay. And we don't need to go to the medium density because presumably that's exactly the same mechanical construct.
I believe so, yes. Yep.
Yeah.
That was the intent in terms of consistency.
Yep. Can you take us to the commercial and mixed use zone?
Sure.
In terms of the same thing, how do you get to ARDIS? Is it entry, or is it through non-compliance with standards?
Yeah. So
does it differ between the central city and the mixed use zone, or is it the same approach for both zones?
Yep, sure. So I have in front of me the.
Then I've got to help. I've actually got your Appendix E.
Oh, great. Yep. I was just going to say, so I'm on Appendix E and I'm at the city centre zone, which I think should be the first zone in the pack. So then for.
Take us to the central city zone, for example. If
Yep,
and
yep.
then we can contrast it with the mixed use if we need to, or the waterfront.
Sure. So the way generally the and actually I think so the city centre zone is separated in terms of additions and alterations rule and a construction rule. So for example, I think it's 19 from the top of my head.
Yes, got
Yep, is alterations and additions to buildings and structures. So there are some qualifiers where some minor alterations, additions are permitted. Otherwise, if you don't meet those requirements, that kicks you into restricted discretionary.
Yes.
And that is where there is the design guide hook. And again,
Sure.
the same application that, for example, we just talked about, the high density zone, applies to the city centre zone. So in terms of, you'll see that there's quite a markup of changes. Originally, it was a direct reference in the matter discretion for the centre zones to the centres and mixed use design guide. Which included at the time the city outcomes, which was placed in the guidelines but is no longer. Instead, looking during the Section 42A process, I recommended that it should rely on the policy hook for design guide rather than a standalone design guide reference as a matter discretion. And that was also in response to submissions received as well in terms of the structure. So that hook there takes you to, so it says matter discretions, the matters in, and lists the policies. In terms of design quality outcome, which talks to the centres and mixed use design guide, that's P9. And then I think I'm correct in saying P10 is the on-site residential amenity.
Yes.
And this one is important to note in terms of, this was where I mentioned that differentiation. So in the quality design outcome, the hook was the centres and mixed use design guide.
Yes.
And then for P10 on the on-site residential amenity, the focus was on the residential design guide.
Yes.
Because it pertained to things like outdoor living space and other standards like unit size, for example.
Yes. Those clauses 4 and 5 are recommended to go, and the policies that are referenced in 1, particularly P9 and P10, do the lifting.
Yes, they do the heavy lifting and connecting. Yeah.
Okay.
So
that's I think that's probably what described as efficient and effective.
I hope
32 cents.
Yeah.
Yeah.
So that main change there in P10 for on-site residential amenity,
Okay.
it just now hooks to the centres and mixed use design guide.
Gotcha. Yep. It's useful. Those so it's compliance with the requirements of CCR 19.
Okay. Just while we're in that area, and CCZ PX retirement villages, I just noted that it's still using the language of meeting the requirements of the guide.
Oh yes, that's a good catch. That should be. I should just check my recommendation just to check if that got. In my recommendation for my section 42A, so recommendation 17 does refer to PX and retirement villages. I suspect it was probably just a mistake that language didn't get carried through. I believe, unless anyone correct me, but I believe it's the fulfilling the intent.
We'll be using those as a baseline for our recommendations in terms of whether we make further changes or what. So they are up to date.
Yes, no, we can.
Yeah.
I can share either an update or include that in my writer reply. I'll seek your direction on what you prefer.
Having a Word version will be useful.
Yep, no, I can do an addendum and share that with you. Yep.
And just take us through the notification approach in terms of that restricted discretionary and the.
Sure.
Under
so
19.
So R19 is the additions and alterations.
Yes.
And I do appreciate it's 3 different settings in terms of notification. So the way that that's been couched in R20 is the same in terms of the construction rule. Yeah. Is that in terms of requiring any public notification flat out, that there isn't that requirement, a notification. And the reason behind that was given it's a city centre zone and direction NPSUD, the notification status kind of is more about enabling development. So in terms of the first one, just refers to where an application for resource consent made in respect of this rule complies with all the identified standards is precluded from being either publicly or limited notified.
Right.
The second statement then sets out based on certain standards. So it says, again, the application for resource consent made in respect of this rule, which results in non-compliance with S5, S9 and S10 is precluded from being either publicly or limited notified. So S5, I believe, is the ground floor building height, S9 is the minimum unit size, and S10 is the outdoor living space standard. So that is where the kind of comfort was that neither publicly or limited notification was necessary in that situation, where there is a compliance with those standards in particular.
Okay.
And then the last statement there is an application for resource consent made in respect of rules for non-compliance with, and then it refers to CCZ S2, 3, 4, 6, 7, 8, and I subsequently added standards 11 to 13 as well.
Yes.
Is precluded from being publicly notified, so it could be limited but not publicly.
Sure.
And those are your standards relating to, maximum building depth, things like that as well as active frontage, minimum building height, for example.
And that approach is pretty much duplicated for R20 also.
Correct, in terms of city centre zone, yep, the construction rule.
And the difference between 19 and 20 is, apart from 19 dealing with adds and alts and 20 dealing with new buildings, is that there are some permitted activities that have a small gross floor area that don't trigger the rule, is it?
Correct.
That's the 100.
So yeah, gross floor area of 100 metres squared or less, or if the building coverage is no more than 20%.
Yeah,
but it's a pretty
subjective,
limited,
isn't it?
And yep,
Yes.
and also compliance with the standards. So I guess it's
Okay.
more limited focus in that in terms of what traditionally be the restricted discretionary activity.
Yeah. But have you given any thought to how enabling?
I haven't kind of,
No.
well, sorry, in terms of, the extent of how many permitted applications there might be. The intent of it was that, it provides for certain situations, but generally applications will go through that restricted discretionary framework in terms of point 2.
Yes. So very much a design-led approach to central city development again, that's similar to the operative plan, but bit more nuanced.
Yeah, I think that's a fair assessment in terms of the focus this time around, I guess, is, responding that now we have MPSUD in terms of the direction there in policy 3, and in terms of probably being more directive and enabling in the notification settings, but also just changes in terms of some new standards in the PDP, for example, compared to the operative, as well as others that have been brought through, but also that design focus as well. Yep.
Okay. The last thing on the central city, in particular on Rule 20, that I noticed is that there's a clause 3, which is also restricted discretionary, and that relates more to height. Can you just explain that?
Yeah,
for
sure.
my benefit, because
So
I wasn't involved in the census zone, so.
Yeah, no problem. So a note with so a key difference, I think, with city outcome is that the decision was made as per my recommendations that it should apply to a construction of a new building, but not to additions and alterations. And I guess that was a bit of a balanced approach in terms of considering that for additions and alterations, applying the city centre zone would be probably too onerous, but then it definitely was appropriate for the construction of buildings that now go above what was in the notified plan, CCZS1, which is the maximum height limits, but is now, as per my recommendations, is now city outcome contribution height threshold based on those maximum heights. So anything above those heights then triggers the city outcome contribution mechanism. So the changes that I have, and possibly just before I mention the city outcome one, number 4 under 20.4 and rule 20.4, I just note that relates to where there's non-compliance with the minimum building height. And that was in the notified plan, but the new number 3, so 20.3, like you've noted, is a restricted discretionary activity still.
I see.
But
Yes.
it basically covers the scenario where city outcome contribution, CCZS1 is exceeded, and then it has a much more focused matter of discretion in terms of the matters in policy 11, which is the city outcome contribution policy, and then also the application and implementation of city outcome, which is in Appendix 16. So it's important to have those references there and then their own notification setting. But I also just know, because I think there has been a little bit of confusion with this, the intent is always that there's still the assessment under 20.2 in terms of, the building itself
Yes.
under the RDA, but then it's just this additional, rule setting for where you also go above the city outcome height thresholds as well, just to ensure that's addressed in the rule framework.
Okay. Just to complete the explanation for the MUZ, how does that differ from the central city approach that you've just described?
Yep. So the mixed use zone doesn't have the city outcome contribution.
No,
line.
no, in terms of
The framework.
the
and
hooks.
Yeah.
Yeah.
I'll just go down to it if that's okay. Through.
And yes. Give me a rule number if you can.
Or just sorry, this is quite a large document, isn't it? Mixed use zone. Oh yeah, so I am on, so the construction rule for mixed use zone
21.
is it's R18, I believe.
Ah,
So in my appendix E, so we're on page 109, I believe. And it's MUZ, what is now being referred to 18, construction of.
oh, MUZ. Sorry, I was on MCZ.
That's right. Was it mixed use zone you wanted to speak to?
Yes, it was. I'm sorry.
That's okay.
Got it. Which not 18? Did you say?
So MUZ R18, it was formerly R16. Yep.
Yes, got that.
And then I believe it's the same hook. I'm just going to jump up in terms of, so you can see that clause 15 and clause 5 and 6 in terms of that matter discretion. So items 5 and 6
Yes.
follow the same approach in terms of the reference to the centres and mixed use design guide and the residential design guide have been removed in favour of that policy hook.
Good.
And I'll just jump up to the policies in terms of that. That is so for the key policies are policy 5 relating to residential activity and also policy 6, the design of new developments.
Right.
So again, same approach there for consistency across the centres and mixed use zones.
Just flip back to that policy, particularly 6, 5 and 6.
Just to follow up. So the hook to the design guides has been simplified by the reference to the policies, and the policies always have a reference to design guides, an appropriate design guide.
Correct.
Okay.
And it's always to the fulfilling the intent of the guideline.
Yes, so
guide. Yes.
consistency of wording there. It's, I guess, a response. Well, firstly, consistency is that was actually the notified wording, particularly for city centre zone, but I also in terms of responding to, I think, well, the Bottomless School Review, but namely also submitters who didn't like the kind of alternative wording at the time was a combination of either meeting the intentions or I think for the city centre zone at one point for the section 42 it was requiring. So it's getting the right language setting there.
Sure.
Yep.
And there was that one error that the chair or identified earlier. Yeah.
Yes.
Yeah.
That'll be corrected. So I think that's PX, which is retirement village policy. Yep.
Yeah, and I noticed that there is a difference between fulfills and fulfilling. HRZ has fulfills and the other ones now have fulfilling. At the end of the day, probably doesn't matter, but they should be consistent.
Oh, probably the best course of actions.
Probably best to get someone who
I'll
has
do an
no
addendum.
involvement with it. Just
I'll get someone with a fine tooth comb, and we'll get that to you in terms of an addendum with just the right setting. Yep.
And none of the other centres have any hooks to design guides, local, neighbourhood.
Yep. So
They
all the
do?
centres do.
All.
Yep. So if in my recommendation 17 in my section 42A, it sets out all the zones and all the applicable policies that connect to the design guide. So that's probably the best steer in terms of which policies and then kind of the associated rule have been updated to.
Just give me that reference in your 42 again.
Yep. So paragraph 212, so 212, and it's recommendation 17. So P2R17.
Thank you. That's really useful, Ms. Stevens. Thank you for that. Are you going? Is there any utility in doing the same for heritage and subdivision, or are you? Can you do that reasonably quickly or?
Possibly, I will, possibly for heritage, I might bring up Mr. McCutcheon if he's happy speaking. Oh, actually, I can probably just do it in terms of, it's not in Appendix E,
No.
but we probably do. Let's just bring up the right hearing stream documents. So if I go to stream 3, Mr. McCutcheon can help me find the right documents. Did you do it, please? Yeah. Yeah, I can open. They're online.
Oh, cool.
Yeah. Awesome, they're online now, so I think we're going to get them open. So that's write a reply appendix. Cheers. Thank you. So then.
Imagine it's a lot easier given that we're dealing with a district-wide rule and it's not limited to differentiation between zones.
Yep. Oh, I'll pass to Mr. McCutcheon. He's grabbing the microphone.
Yeah, so this is the document I referred to this morning, Commissioner McMahon. So it's online now. Cool. So if we take ourselves to recommended HHP 14.
Policy as opposed to the rule.
Yeah, so all of the references to fulfilling the intent fulfills the intent of the Heritage Design Guide located in the policies. There's no other references in the rules. So HHR 14 is an example of the policy for additions and alterations and partial demolition of buildings and structures. Yeah, P14. So number 1, J, is the extent to which the work fulfills the intent of the Heritage Design Guide.
Yep, got it.
Similarly, if we made our way to HHP 8, just a few policies up. We'll find, yep, just cut off the page below, the top of the page below, sorry, there we go, fulfills the intent of the Heritage Design Guide. So the reason that there have been no additional track change chapters provided as part of the Stevens 42 is that, fortunately, by luck, coincidentally, all of the references in the Heritage chapter talk to fulfilling the intent of the Heritage Design Guide.
What's the topic of those two policies, 14 and 8?
So 14 was adds and alts to buildings within heritage areas, and HHP 8 is new buildings or modification of non-scheduled things on the site of a heritage building.
Yes, and there'll be rules associated with those.
Correct. There are also references to an assessment against the Heritage Design Guide for adds and alts to a heritage building itself, and for new buildings and structures within heritage areas.
They're both ARDIS or?
Everything is ARDIS apart from, in the Heritage chapter generally, apart from total demolition, which is discretionary, as well as relocation, which is discretionary.
Can you, just for completeness, can you give us the rules, the two rules?
Certainly.
Adds and alts and use.
So relating to the ones that I just spoke about, so new buildings and structures is recommended rule HHR8.
All right, yes.
And that the policy hook is embedded within the second clause of that rule. And then the other one which we talked about was adds and alts to buildings within heritage areas. And that one is HHR 19.
19. Good. Thank you.
I'll just ask too. So the idea, the intent, is that each design guide has an intent statement at the beginning of it. So that fulfilling the intent, you go straight to that in the design guide to see what the intent is.
That's correct. Yep.
Does it apply to the subdivision design guide? Do you know?
I believe it does.
Because I couldn't see it on the online version of it. So
Should be, I believe, in the beginning of it.
Or does it not, is the policy,
Oh, yeah.
relevant policy references don't talk about?
Yep, no, so and I'll just summon the appendix. I'll just check which one. So appended to the bottom of school report. So on page 123 is the subdivision design guide. That was the recommended.
Okay. Yes.
And there's a section right at the beginning that says intent.
Okay.
So that's a consistency element in terms of the intent being in the guides itself, and then kind of that connection there. Yep, with the policy hook. Sorry.
Thank you.
And just finally for subdivisions.
Sure. I believe there should be a subdivision chapter within my appendix E. So I'm just.
Oh, okay. Yes, there.
See if I'm on the right page.
No, mixed use.
It's not within that. Okay.
No.
What I will do is I'll just check hearing 5. One moment.
It's probably not as essential to see it. If you can just tell us the policy and rule.
Yep, and I know as well, having refreshed myself on Ms. Van Haren Giles' Section 42A report, that it was the recommendations that it aligned with obviously the design review process in terms of the outcome and the same policy hooks. But I'll just see the updated one. One moment. So Ms. Van Haren Giles has updated as per hearing stream 5 recommendations. So for example, I'm on subdivision P3, so sub P3, sustainable design, and she's added the wording fulfill the intent of the subdivision design guide. So again, same policy, and then in the rule framework, it's that same hook as well. And I hope I'm correct in remembering that the intent was there that seemed to be that missing connection in the policy framework, so ensuring that the design guide reference is in there for consistency.
Okay, and
Just check if there's any. So in terms of the rules,
maybe no, presumably there's no effectively any permitted subdivisions other than what's the general entry level controlled or restricted discretionary for subdivision.
so there's just looking at it now, for example, there's some permitted clauses around, for example, subdivision around existing lawfully established building, which does not result in the creation of any new undeveloped allotment.
Sure.
Another example, boundary adjustments.
Yes.
So there's a few situations, but largely appears to be controlled or RDA, from what I can see.
But I guess is the design guide referenced in any controlled activities, or is it
restricted discretionary?
Restricted discretionary.
Yep, correct.
And can you just give me a rule example?
Yep. So there's a couple. I'll just check here. So rule. So subdivision R3 boundary adjustments. So sorry, correct that. Sub R3.3.
3.3.
Actually, sorry, I'm just going to check. I just want to make sure I'm setting you on the right path with the design guide reference. So policy is P3. Correct, yep. So that was subdivision R3 boundary adjustments, so R3.3 for the RDA. And that's where the matter of discretion number 2, which said the matters in the subdivision design guide has been struck out, and it's just relying on that policy reference. So the matters in sub P3, so that consistent approach.
Yes.
And then
what about a more substantive? I mean, is it all subdivision that's RDIS, or is it just undersized subdivisions that are subject to the design
in
guide?
terms of design guide, so the next rule, for example, R5 is subdivision that creates any vacant allotment, excluding new allotments for infrastructure. So I think I'm correct in saying there's only 2 rules that connect to the design guide. Just double check that actually. There's yes, correct. So that's
3.3 and R5.
And yep, so R5.2. And I also just note as well that 5.2 matter of discretion number 6 says that for subdivisions in the general rural zone, the matters in the rural design guide apply, which obviously hasn't been subject to this process, but yes, for completeness.
Is there a rural design guide?
There is. Yes, which will be, I believe will be heard possibly in stream 7, 6, yep,
Next year.
next year.
Hey, look, that's been really useful. Appreciate that.
Did you want to step into the design guide itself, or are you comfortable with the intent and?
Oh, no. No, we don't. I think this is more the mechanics of how it all works,
Sure.
and addressing some of the key issues raised by submitters. One thing that did occur to me in terms of looking at intent is the whole issue around design outcomes, and because the home for design outcomes are in the design guides. The question from Kaingoa is whether they should be in the policies as well. We have read your views on that and your assessment, but maybe you could just talk us through why you don't think the policy, because some of the policies that I was reading do seem to have some outcome kind of statements in them. So that leads me to think, or should they be like holistic outcome statements in themselves as per Kaingoa, or whether they should not do that at all. So,
Sure.
yeah.
So, yeah, as you noted, addressed in my rebuttal. So I think it's Mr. Hill's evidence, possibly might have been the legal sub, that talked about in the centres of mixed use in particular, there are some connections in terms of the outcomes to the policy, less so in terms of the residential zones. But I guess at a crude level, my feeling would be that it would be almost like a duplication or a double dipping in terms of, you know, if you have design outcomes and you place in the policies, whereas I think there is alignment between the two in terms of the connection between the design guide and the district plan. But I also note that the kind of policies, it's not really just the design outcomes, it's also other things that the policies address as well. And I think, in my perspective, you don't need to kind of duplicate or have verbatim wording, because it just feels like a double dipping in my mind. So that's generally where I've landed. I think there is definitely some synergy in terms of in that connection there. For example, the quality design outcomes policy, which is probably the strongest connection to the design guide wording. I think probably and it probably passed to Dr. Zamani in terms of the origins of design outcomes, but there definitely was done kind of in tandem, but with obviously kind of one focus being the design guide review, and then the other being the review of the policies and the chapters themselves. But I think they do have a lot of kind of connection there. But
because I'm just looking at policy 9 for the central city, and it talks about quality design outcomes, and then it lists a long list there. So I'm just wondering whether there is still an inherent amount of overlap between the policies and some of the design outcomes in the design guides.
Sure. Probably think as well, it's almost a little bit of a alignment of timeframes as well, but given that, you know, the centres of mixed use and the residential was heard in stream 2 and 4, and now this is the outcomes is focused on in a later hearing stream. So probably in an ideal situation, it would have been at the same time as it's intended, but certainly I think the design outcomes, because it connects to design guides through that policy hook, there is that connection there, and I think it's probably happened that it does share that same outcome. But I wouldn't say that kind of I've since gone back through and retrospectively looked at or marked up about how the policy should change, because I don't consider it needs to.
So is that sorry about this, is that a consistent approach of the policies to talk about design outcomes, and wherever there's a policy that references design guides, they also talk about design outcomes across the board, or is that just related only to the centres zones?
Yeah, I'm a little bit hesitant in terms of residential, given it's not my area, but I would say in terms of certainly for, sorry, just backtracking. I might just get you to repeat the question.
No,
okay.
I'm just saying, so it seems to me like there's a consistent approach for the centre zones to have a policy that talks about quality design outcomes.
Yeah.
But that doesn't extend to the residential zones or anything. There's a slightly different approach
Yeah, so for the centre zones, it certainly is the case that the kind of, I guess, design focus policies where there is that hook for design guides. For the residential, it's slightly different in terms of kind of the policy setting that was given from, I believe, MDRS policy, and I hope I'm correct in saying that, but also generally, I guess, because of the different focus areas and the different guides as well. So you don't see kind of that same, I guess, connection in the residential zones that you do for, say, the centre zones, where it is quite, even the heading says design outcomes. It's quite different in terms of just how that has been phrased and set up based on, I guess, both legislation, but also direction and probably different focuses of the different zones as well. But certainly I think there is that connection, at least consistency across the centres and mixed use zones in terms of they all have that same design outcome policy focus, and then also for that residential amenity focus as well in terms of the residential design guide, well, centres and mixed use design guide hook. Probably more about the heading, I guess, of the policy that seems to probably provide that strongest connection in terms of outcome per se.
Because I'm just trying to get my head around the issue of where the design outcomes, where the appropriate home for them are. Are they, so they're in the policy, or are they in the design guide, or they're a bit of both?
Yeah.
And if so, is there a logic to that split?
I might pass over to possibly Dr. Zamani, but I would just note, kind of reflecting, for example, so probably CCZ P9, so the quality design outcome, when drafting that policy, the focus is both on kind of connecting that to the design guide in terms of, fulfilling the intent, but it also, I guess, is a policy reference hooking back to other standards. And a little bit of that difference there with the design guide is that really the focus of the design guide has not been to replicate any standards, so any double dipping in terms of obviously it's around design considerations, but it's not around having a guide that replicates what a standard does in terms of that. So part of that policy is, yes, it does connect to the design guides, but it also covers more in terms of being connections for, residential amenity or streetscape function, things like that as well. So it covers, I think, the policies, the intent is, yes, connecting back to the design guides, but covering more broadly other aspects that relate to wider provisions in that zone. So my personal perspective is that I don't think that the design outcomes need to be replicated in a plan. It kind of would feel a little bit, I guess, retrospective in terms of trying to write them in, but I also think they both have their place and they kind of work in unison is my perspective. But I'll pass to Dr. Zamani in terms of the origins.
Okay, because I'm interested, are the design outcomes in the policies, say P9 for the central city, different to the design outcomes in the design guides? And if so, what's that relationship? Do you know? I mean, there's a fairly long list there. Is there a neat symbiotic relationship between the two? That
And I guess the question is, has that exercise been undertaken to compare the outcomes in those two sources?
I might pass to Mr. Banks if that's okay. In terms of, I think that's probably very much in terms of the review that would have spoken to that, but I think fundamentally, they are different. It wasn't that one was prepared with the other, but I will pass it on.
So within the context of the review, our scope was to look at the design outcomes that were within the design guides. And as part of our review, we assessed whether or not they were inconsistent with things up in the plan. But we weren't reverse engineering stuff in the plan, right? So we were just looking at the design outcomes in the design guides. And so we've done that exercise in terms of looking at the outcomes in the design guides and making sure that those aren't inconsistent with outcomes that are located across the plan.
Did you identify any outcomes in the design guides that were inconsistent with the outcomes expressed in the policy?
Can I get back to you on that? Because I'll do a deep dive into our
You can, but I thought you might have known the answer off the top.
we did remove. I know we removed an outcome, right, not because it was inconsistent, but because it was overly broad. Yes. So we couldn't really trace it back to an individual part of the plan above it. Yeah. So I guess that's probably the best example.
And if you do get back to us, the question is, what do we do with that information? I mean, if there are if there are inconsistencies, what's the recommendation to us?
Perhaps I could express the question differently. So that review, in terms of what the design outcomes are in the design guides, has sorted out that they're not repeating the design guides and the policies. Is it that a subset, if you like, of outcomes?
No, it's sorted out that they weren't inconsistent with them, right? But there are design outcomes that reflect, for example, strategic direction, and are consistent with them, with strategic direction. So, yeah, in regards to the design outcomes, we weren't removing double ups. We were making sure there was consistency, or at least no inconsistency. When it came down to guidance points, which are more directive, that's where we were looking at removing things that were already regulated in the plan or through other regulation.
So you're satisfied that as far as the design guides are concerned, there's no redundancy, or there's no unnecessary duplication in those design guides themselves for the outcomes. As to how they compare, how the outcomes in the design guides compare to the policy ones, your exercise went only as far as identifying no inconsistency.
Yeah, that's correct. And the thinking there was that, well, if you're achieving an outcome in the design guide, you'd also be achieving it elsewhere where it's the consistent outcome as mentioned elsewhere in policy.
Sure.
Yeah.
If I could just add further context to that, it's building off what Andrew said, but I think we're looking kind of reflecting out the outcomes and remembering back to the drafting period. The intent was not to kind of replicate any design guides or guidance or anything like that in the policy, just in terms of avoiding duplication, excessive policy direction. And I think also looking at these outcomes, some aspects, while they're connected to, say, city centre zone, for example, they might also be covered in another chapter as well. So, for example, number 6 talks about mana whenua sites and significance are acknowledged and celebrated. So that is in the policy hook, but it hasn't got a policy headline in the city centre zone, for example. It's more around, for example, I have it here, ensuring the development where relevant responds to adjacent sites and things like that as well. So I think if anything, it kind of sits quite nicely in a supportive manner to what's in the policies, but the policy never set to replicate what's in the design guide.
Yes.
And I think there's that synergy there for me, and some things are more direct, but there's also more, obviously the outcomes are much more design focused and don't need to always replicate the policy.
Isn't part of the problem with the title of like CCZ P9, you're talking about quality design outcomes, and then you've got a design guide which has got 18, centres mixed use, it's got 18 design outcomes, but the policy's got potentially different stuff in it than is actually located in the design guides itself.
I agree, looking at that possibly outcomes has created some confusion with the wording there in the policy, and from my perspective it could be changed.
Yeah. So, this is when I've been thinking about this, the P9, CCZ P9 is right at the guts, if you like, of what you're trying to do for a central city design, and the things that you need to consider. Whereas the design guide is more about, if you like, when you're looking at these designs, these are the outcomes which you need to strive towards, and they might be different or there might be duplication. So it's whether there's an easy, coherent way through it.
I think maybe, sorry, didn't mean to interrupt. Possibly the fix is that kind of, I guess, the policies are focused on the development outcomes. So that's probably the nuance there in terms of possibly refer to, quality development outcomes as opposed to design outcomes. And I think that's the crux of it, the development outcomes in the policy, and then versus obviously the design guide design outcomes. So more of that focus on the development side of things in terms of the policy framework. Yeah, but I take your point in terms of what you've noted.
Just on that point, presumably if there was to be a change to P9 to refer to, say, you mentioned quality development outcomes, there'd be consequential changes across a number of different chapters as well, or a number of different zones, which have the same sort of principle, like residential, for example?
I believe I'm correct in saying that mainly the flow-on effect would be on the centres zones, because there's been that consistency of drafting and policy direction. So I think it would largely apply to centres because the medium density and high density, the policy wording is different. Yep. The heading, sorry.
Just two things arising from there. Again, you just satisfy us that you've done an exercise that gives us confidence that the focus of the policies is on development outcomes and that the focus of the design guides is on design outcomes. Are you comfortable that that is the case consistently?
I am comfortable that that's the case in terms of that was definitely the intent. And
Yep.
I can, if you'd like me to speak to that further and write a reply, I can definitely do so.
No, that's fine. It was the same question I asked you earlier about going through the exercise, or the question I put to Mr. McCutcheon actually, more about going through the exercise as opposed to the answer itself.
Yeah, but I am comfortable with that outcome, but it might be something for me to think about.
Yeah, I think a good example is in CCZ P9 2C, so where it responds to any identified significant natural hazard risks and climate change effects, including strengthening and adaptive reuse of existing buildings. If you look at that, it's not really about design, which is what the title of that policy says. So that's an example of, it's as I potentially think you're right. It's about development outcomes, what you're trying to achieve in the central city zone relating to a built development, whether it be existing or not. So I think that might be the crux of the problem.
I'd agree with that. Yep.
The second question I had was, I see, and it's been consistently applied, that the words as relevant or relevant from clause 1 has been deleted, and fulfilling the intent of the design guide as relevant. And I just wondered if you could take me through the background as to why those words were deleted. What the rationale?
Yeah, I can step you through. So I note that addition of as relevant was connected to where there was the 42A recommendation where the wording was meeting the requirements. I think that as relevant was added just to make it clear that the intended design guides is not every guideline will be applicable to a development. And I think that's quite an important point to note, because there are obviously have been concerns in terms of having to make an assessment against every guideline. So that was really, I guess, a softening and just making it clear where the wording originally was meeting the requirements. I think in terms of that change to fulfilling the intent, still is intended to direct that not all guidelines will be applicable to a development. So it just felt that the qualify as relevant wasn't needed when it was fulfilling the intent, and it's that softer wording from requiring to fulfilling. Yep.
If the panel was of a mind to add that word across the board, would you think it might provide some additional guidance at the consenting stage?
Possibly. I suspect it might go down better with submitters as well in terms of some of that feedback that we have got. Because from my perspective, that's fine.
I can remember the late night hearing we had a bit way back, hearing stream 2, was it 3? We heard from Mr. McIndoe and Mr. Burns and others who were at that stage were quite keen on referring to the relevant outcomes and relevant principles, and that's why I thought that might have had the genesis.
Yeah, and I think it possibly was in response to submissions as well. I'm casting my mind back, but I think certainly in terms of observing the expert conferencing, and I agree in terms of what feedback I've heard as an observer, that as relevant it may be useful just to connect to that kind of.
And it wouldn't have any unintended consequences that you can think of?
Not that I can think of the top of my head. I will pass on just because I think Mr. Banks might have commentary, but I think the focus now of the guidelines and that 2-tier approach is really around that directive versus consider. And I think as long as the as relevant still makes that clear. And I think the wording that I have added subsequently, which I believe was largely Mr. Hill's suggested, Mr. Ray's suggested wording, as long as it's clear that, you know, there are the directive guidelines that need to be assessed.
Yes.
And it, noting I'm not a design expert, but, you know, it's part of that assessment, just noting where guidelines are relevant or not, and just having that in the assessment, I believe was the intent, but I will pass over because I don't want to speak out of turn.
No, I understand what you're saying. We need to keep in mind that it didn't conflate the direction and consideration type approaches in that 2-tier.
Yeah, just to note on that, obviously the issue of relevance was canvassed during the expert conferencing, and so the whether or not guidance or outcomes themselves are relevant is actually now built as a mechanism built into the design guides themselves. So the introduction to each of the design guides now includes a statement that says the design guides are intended to be applied in a manner that recognises the unique nature of individual proposals. Applicants need only apply those design outcomes and guidance points that are relevant to the proposal. That's been incorporated now into the guides themselves and under the heading how to use this guide.
How to use. Yep. That's really useful. Thank you.
I'm just thinking that as relevant clause would perhaps address some of the submitters like Woolworths and things in terms of operational and functional need kind of questions they've raised.
Possibly, in terms of whether they are happy with that relief. I would just say kind of my position has been, and I know Dr. Zamani as well, that I didn't feel it was appropriate to provide, you know, exclusions or from applying the design guide to particular types of activity, you know, whether it be retirement villages or also for, you know, not needing to apply a guideline for operational or functional matters, and that then that cascade effect would have, if that was to be given effect to, noting that that's considered in the realm in terms of the provisions as we canvassed in stream 4, but, you know, it may give satisfaction to the submitters, but I would also want to note that they still would need to do that assessment, and that obviously that would need to be reviewed as part of the urban design assessment from council's officer perspective, as well as whether correct in the design statement, and I guess it would be up to the council's urban designer to ensure that something has not been missed that needs to be as part of the design consideration based on the functional operational requirement set by, say, a Woolworths or something like that. But I don't know if Dr. Zamani has some comments on that.
The only probably something to add to what Ms. Stevens said is that those operational and functional needs have a different lifetime of the building, and the building may stay, but not those operational needs. They may change the building, change different uses. So that's why I believe that it needs to be looked at specifically on a case-by-case scenario during the resource consent application to look at those specific contexts. And if there is possibility of those operational needs to change, then the council officers can consider different aspects to ensure the basically making sure that the urban environment is future-proof.
Notes? I'm aware, Dr. Zamani, that we've only got you till 1 and then it has to be for a few hours.
And so, I will be back at 3.
Yeah, let's come back, and I think it's a question for you as well as for Dr. Zamani to figure out what is covered by the design guides. Is the urban design guide what it should be covering, maybe what it should be called, or is the content bigger than urban design?
I think for that aspect, I know Dr. Zamani has a response. Probably better to address that first. I will just note that I have since read Guy Marriage's submission point, which you put to Mr. McCutcheon. Yep. But I'll let Dr. Zamani go first.
Just double check that I'm not wrong. I think in terms of your question, in terms of the difference between urban design and design, I think that's a very philosophical question that what urban means and what urban design is. My understanding is that urban design can be considered very holistic. That includes architectural matters, landscape matters, and also the wider impacts of the design on the city. Is not very there is a misconception that urban design is considered as landscape architecture. That's not the case. However, the urban design officers of the council, they sit within the design review team of Wellington City Council. So, and I think that's where the confusion comes from. The urban design panel versus the design review panel, basically interchangeably used commonly around the world. If even you Google urban design panel, some cities call it design review panel, some cities call it design panels, and some cities call it urban design panel. I think the submission by Mr. Marriage is actually, he's referring to urban design panel, considering that I had a number of conversations with him. However, we have design review panels that if you look at those ones and the term of reference, they cover a wider range of design matters, including, for instance, the impact of transport on the design or vice versa, while urban design, it may be limited. But yeah, within my statement of evidence, I explained that I believe that urban design covers a wider range of things that some of the submitters have considered.
Yeah, because you know the submitters were saying the design guides include things that shouldn't be in there because they have nothing to do with urban design, and their view of urban design, as I understand it, is that urban design is what you see on the outside, what the outside contributes to a function within the city. Whereas things like storage facilities within a building, for example, do not contribute to that, and therefore, in their view, there is no link in the design guide to include it. And we have to make a decision on that, so I need to understand where the council's point of view is in terms of what goes in. And you were saying, you know, you see that as a much more holistic way and much more inclusive. But I have to say, as a person with an architectural background myself, and I know that you have got one, and I know that other urban designers often are planners, I think this might be where the different viewpoints come from. That as an architect, you think bigger picture areas, the planner and urban design thinks about the city as such and not about the building.
That's correct. I disagree with that point of view, and I believe urban design includes those internal amenity issues. Is part of the definition of urban. It's holistic term. Covers anything that part of that environment, and I don't think it, like what they basically arguing is that if the design guys should only deal with the external design. I totally disagree with that.
Okay, great, thanks very much for that.
Questions from? It seems to me there's a sort of a hanging question there around terminology used in the policies versus the design guides, which we might return to later today. But it seems that you were sort of open to maybe some terminology changes to maybe clarify the difference between the policy design outcome and the design guide.
Yeah, I agree that some clarity could be provided. I mean, looking at P9, as we've talked about, and just making that clear around the development side of things. And I think Commissioner Dash mentioned in terms of the fact it is that broader scope in that policy. So definitely happy to consider that.
You know, I don't know if it's put too late, but the issue around an introduction to design guides, where have we landed in terms of council's recommendations for that?
So in my rebuttal evidence, I kind of canvassed and I essentially landed that there could be 3 options, which I explored in terms of retaining it in the notified plan in terms of that introduction guide. The second option was deleting it in its entirety. And the third option was retaining it, but placing it as a non-statutory guide, available on our website to give context to plan users. Where I landed in my rebuttal was that I considered, because the extensive design guide review process there has been, and the kind of some updates in terminology and the outcomes and the intent sitting in the guides, I think there's some language that we use within the submitted expert evidence was that these guides sit in themselves, individual documents. I landed in my rebuttal evidence that I consider that at first it needs to be removed from the notified plan, but I am comfortable with the option of it being deleted versus also I'm comfortable with it being retained. I think, obviously, I appreciate you'd want me to make a steer one way or another. And personally, I think my view is that having reviewed it, there is really useful information in there around contextual analysis of setting the scene to the design guide review, but also important aspects, including partnership with mana whenua, their involvement in the design process and design more generally in terms of their involvement, the conversations we've had, the engagement we've had with our stakeholder, so our mana whenua partners. And also, I know that the history there in terms of having Māori designers involved in the process as well. So I know a lot of work went into that introduction design guide. I think it's quite useful in terms of, I guess, speaking at a high level, the connection to the plan. And I think if I had to land on a position, I'd probably say it is a useful document that sits outside the plan, a non-statutory document. But I also will pass through Dr. Zamani because I know best to lay the scene and give context.
The only kind of comment that I wanted to make on top of my statement of evidence was about this issue, because I didn't knew about the options regarding the introduction chapter of the design guides. And upon reflection of Ms. Stevens' rebuttals, I believe that basically removing this chapter from the plan and having it as a contextual overview of the design guides, but in a non-statutory as a non-statutory document, I'm very comfortable with that. I think it still provides some overview, some contextual background, but it's not basically interfering with the coherence of the design guides itself. Is basically sitting outside as a additional reading, basically, if someone wants to have a better understanding of that context or foundation of the design guide.
So another option, just to explore it a little further, did you consider the option of putting a big chunk of the introduction and the introduction thing into the introduction of the design guides themselves, so that they're whole to themselves and don't rely on reference to either within the district plan or outside the district plan, but there's no requirement to then go out to, if you want further information about how these design guides were prepared, etc. Did some thought given to sort of putting elements of that into each of the design guides?
Probably best to pass to Dr. Zamani or Mr. Banks in terms of that process, possibly only because I was privy to expert conferencing session 2 and 3, but I'm not sure if it was discussed at number 1, which I wasn't involved with. But I might pass them before I kind of speak to it in terms of my considerations.
I'd just say the direction of travel in the expert conferencing was not to do that. I mean, it really wasn't an option on the table in terms of the outcomes of expert conferencing, because the feedback, certainly at a high level, was that that document was not helpful. So we certainly didn't want to go against the grain of expert conferencing by bringing that document into the introduction to each individual design guide. So that's my comment in relation to the review process.
Yeah, I do agree. I think during the expert conferencing, they didn't find the document useful, so we didn't spend any time discussing that. And that's why I'm very comfortable to remove the statutory aspect of the document and keep it as a contextual document rather than trying to make the introduction of each chapter way bigger. I think the introduction of chapters are really nicely kind of explaining what the design guides do, and still my preference is that not to have the introduction chapter mixed with the design guides itself.
That leads me to another question. What about the dilemma of the waterfront zone and its reference to it? Where has that landed?
So I can probably just give some context to that as well.
Yeah.
You know, thinking back to the time of drafting the waterfront zone and discussions with Mr. Wharton, topic lead. So with the waterfront in particular, because there's no updated waterfront framework, and because I believe, and I won't get the detail correct, but in terms of case law and referencing the waterfront framework, we didn't want to go down that track. But at the time, in terms of the kind of guidance, decision was made that in terms of the rule framework, and I think from memory it might be the restricted discretionary, but the rules kind of connect to that introduction document in terms of more generally, I think the principles and the outcome that that design guide introduction document speaks to. So kind of it was more that broader consideration, I guess, for the waterfront zone. But I actually have a lot more comfort with where it has landed now based on the expert conferencing design guide review that the centres and mixed use design guide applies to the waterfront rather than that introduction guide. Mostly because obviously we were landed with the guide in terms of my recommendation, but also because I think there is, and there always kind of has been through this review process, but also the origins of the operative plan with this land and harbour area sitting within the central area, so that connection to the city centre zone. I think I have comfort there with the centres and mixed use design guide applying where appropriate to the waterfront zone, because also there is a lot of consistency in the provisions for the city centre zone and the waterfront. Noting not all consistent, obviously height is different and other aspects as well, but some policy considerations and some standards are in both. So I think that's why centres and mixed use design guide reference is more appropriate in my mind, and I had comfort with that conclusion of the expert conferencing joint witness statement.
Was there any part of the introductory document that was of specific relevance to the waterfront zone that it was referring to? There's a generic reference to it, but I couldn't quite understand what it was about the introductory document that was of particular relevance to the waterfront zone, or I may have just missed that.
We'll just want to double check that and come back to you in terms of specific references. I've just got the waterfront zone in front of me, so I'm just scrolling down to the connection. So the wording, for example, so I'm just looking at WFZ R14, additions and alterations to buildings and structures in the waterfront zone. And one of the references, so for say Queen's Wharf buildings, so that rule for R14.4, it talks around the assessment of the activity must have regard to the principles and outcomes of the Wellington City Council Design Guide introduction. I note there that just looking at that appendix, I know that the year's been removed, but I think probably a consequential change just looking at this now. It also needs to refer to the Centres and Mixed Use Design Guide, so I just picked that up and I'll address that as part of that consistency element in terms of that direction. So I'm not familiar, and I might turn to Dr. Zamani if he remembers anything in terms of the waterfront zone, but I think generally it was having some sort of design guide connection in the waterfront zone, noting that the state of the current waterfront framework and not wanting to reference that. So that was kind of the intent, well, from my understanding at drafting phase.
So there was nothing specific in the principles and outcomes in that design guide's introduction that was really relevant to the waterfront zone. It has some historical connection. And
No, I think it was purely to ensure that there is some level of design measures applied to the waterfront zone, and the principles and outcomes was basically the easiest kind of approach to apply them to the Wellington waterfront to ensure that there is some kind of design controls applied without really getting into specific design guides for the waterfront until we would review the Wellington waterfront framework.
A note, having just reviewed it, so at the notified plan, that there isn't any specific reference to waterfront, and possibly was just a synergy aspect that it didn't, but I also would say that probably, as the Dr. Zamani has talked about, that introduction is kind of that step above, so it hasn't gone down, and because it is an introduction document, it hasn't gone down into specific zones or areas, and that wasn't the intent. But I appreciate that creates a little bit of a disjunction between that notified reference to it and that. But I think, as Dr. Zamani has said, it's that there was some sort of connection there for the waterfront zone, and it didn't go without any connection to a design guide.
So just to clarify, that you're now recommending that these statements in the waterfront zone rules now refer to the CMU design guide, the centres.
So we'll just check, Ms. Banks, that I'm correct in terms of that recommendation, and the intent of that from the review. But certainly my understanding is with the new centres in mixed use design guide, sorry, the updated, that it now applies to the waterfront zone. So I think kind of just reflecting on that policy, I believe the intent would be that it actually refers directly to the centres and mixed use design guide as opposed to the introduction guide, obviously depending on whatever the fate of that guide is. But it certainly needs to have a hook in the zone itself back to the centres and mixed use design guide. But I would also just want to talk that through with Ms. Wharton as well, noting I'm not the public lead as well.
Yeah, because I was going to ask whether you're comfortable that the revised centres design guide, shorthanded, would work for the waterfront zone. So you might, Mr. Wharton made.
I'll check with Ms. Wharton, and I guess I might, part of that question I'll address to Mr. Banks and Dr. Zamani, but I would say that from my perspective, I am comfortable with the centres and mixed use design guide applying. I think probably that qualifier in terms of that language is, fulfills the intent, and if where relevant is brought back, and I think that's important in terms of, as I've mentioned, not all the kind of provisions or standards or policies of the waterfront zone are the same as the other centre zones, and that's because of the unique area. It's a special purpose zone, different focus, and always has had. So I think a part of that qualifier is that it wouldn't, not all guidelines and outcomes will be specific to the waterfront or appropriate. It will be kind of that assessment that needs to be done as part of the design statement. But I'll check with Mr. Banks and Dr. Zamani.
Okay, thank you.
Well, I'm mindful I'm not here to present evidence. I actually think that in terms of where we landed with the design review and that introduction document, all we did was made consequential changes to that introduction document to reflect the changes that were made at the level we were evaluating or looking at the design guides at with the experts. In terms of whether or not the centre and mixed use design guide is appropriate for the waterfront zone, I'd leave that with Dr. Zamani.
I do believe that would be appropriate, considering the amount of improvements that we have in the city centres and mixed use design guides. I also believe that that kind of where relevant aspect would apply the same to the Wellington waterfront kind of zone. That if we have a new development within that zone, they can basically through their design statement explain which parts of the design guide would apply and which part they don't. I do not see a significant difference now between the Wellington waterfront and the rest of the central city. In certain ways, there are certain aspects that they're significantly different and they have to consider, but from a design point of view, I don't think there's a significant difference.
I just would have thought, given the history of the waterfront zone, there's a much greater level of public realm considerations that might need to be given to the buildings there than you might for private development here. I know, without knowing the intricacies of the design guide, I can't really have any conclusion.
I do agree, but when you look at the buildings that they've been built, I mean, they're not necessarily the most public friendly buildings, and that was under the current operative framework through the tag and through all the environment court cases. So applying the new design guides, I think potentially can even lead to better outcomes for the public realm of the Wellington waterfront.
I might just note, if I can, following on from that possibly that acknowledging what you're saying around that public realm focus and that probably that particular focus of the waterfront relevant to the city centre zone I believe that that's kind of canvassed within the policy framework of the waterfront zone, and there's a much more focus on that, and also kind of reflected in terms of activity status as well for development on the waterfront. So possibly that's covered to a degree more through the provisions itself.
Okay, I'm just looking at the time. Unless there's some burning follow-up questions, yes.
Quick question from me. So, and you've talked about the importance of the development of the introduction and with the mana whenua partners. I'm not sure how that flowed through to the individual guides, but given the changes that have been had, is there a risk that some features that were important to mana whenua have been lost or changed through, or that the intention is now different to what was originally proposed through the development?
Sure. I will hand to Mr. Banks because I think he'll address this as well in terms of the review side of things. But certainly my focus, I guess, as an observer and in my Section 42A officer capacity, and I know the same for Dr. Zamani from statement of evidence, that I was very particular about whatever kind of came out of the review process, that I sought that the mana whenua site significance outcome and guidance remain in the plan, because I've been privy to the context in terms of how that was formed, how that was included in the plan. I'm trying to put this the right way, but I think in terms of the review process, some questions were raised by experts as just wanting to ensure that there wasn't kind of duplication versus what's in the provisions versus what's in the design guides. But I think, get the right appendix here, but when you look at the joint witness statement in terms of where it goes guide by guide and talks to those changes, there's a kind of further analysis piece that's been part of the review, and I think that's quite important, just noting that actually, and what was reflected, and I think there's a key difference between the expert conferencing of, I think, day 2 versus day 3, is it was looked into the plan of what does the plan cover versus the guide, and it actually was really important that that was retained in terms of the outcome and the guidance, so that nothing was lost. So that was really much the focus of actually ensuring that where a development is adjacent, it has appropriate design considerations in terms of sympathy to sites and areas of significance, for example. Personally, from my perspective, I very much wanted it to be retained in terms of I know the connection, I know those involved with it, and I think it's really important from our partnership perspective in terms of those being retained. So as far as I know, those haven't been amended, and also very much carried through both the centres and mixed use and the residential design guide, but I will pass over.
Yes, so the proposed design guides as notified, the centres and mixed use and the residential design guide, each included one design outcome and one guidance point that specifically referred to mana whenua sites of significance. The outcome was not changed through the process. The guidance was amended through the joint witness statement to, if I remember correctly, instead of it referred to Wellington's Tiriti partners, and I think it now refers to Wellington's tangata whenua, and that was about specificity. Now, the caveat on all of this is that mana whenua didn't have experts in the conferencing. And so I can't assume that that's the only outcome or guidance point that might have been of relevance or value to mana whenua. I'm sure they all are. But we didn't have that evidence in front of us through the expert conferencing. But in relation to those two particular points, they retain their, well, the outcome has not changed, and the guidance point retains its intent, but is more clear.
So Dr. Zamani as well.
Just a bit of a context to the engagement with mana whenua through the 1.5 year kind of workshopping. They have reviewed all the design guides, so it wasn't just specifically those 2 specific design guides, and they had input into all of the outcomes and the design guides. And I believe that quite a lot of the things that they aspire to have for the city from a mana whenua point of view, but also from the public point of view and the well-being of the people, I think a lot of those are retained and improved, considering that we haven't had any loss of content in the design guides. We removed the duplications and improved the structure. So I still believe that a lot of those aspirations of mana whenua are retained. There, as Ms. Banks has mentioned, there's like those specific ones that there is a minor change in the terminology, but the rest is that the introduction chapter, on the other hand, provides a very kind of more in-depth background to their involvement, and that's one of the key reasons that I would like to retain it as a non-statutory document. But because it was kind of quiet, it was part of their vision for the design guide, the mana whenua's vision for the design guide. So that was set into the introduction chapter, and that's the key reason I would like that to be retained.
So with the introduction, if it's decided that it be non-statutory, you know, how would that be triggered, and what would its use be? You know, just considering what you've just said.
It won't be.
Yeah.
And I'm very conscious of that, but this is the process, and unfortunately this is what the experts found not useful. This is where we landed, and I feel like what's the second best option, and that's retaining this document as a background text, and then hopefully we can add some of the demands and aspirations of mana whenua through different policies at Wellington City Council.
So I'm conscious that, you know, there wasn't any mana whenua input into the review process, and, you know, you say that, you know, the outcome's unchanged, but the guidance may have been amended. There might be some terminology changes, but I'm just concerned that the terminology changes do have wider impact. You know, if you're changing Māori words to European words, that context can change dramatically. So whether or not that sort of, it's that level of change or not, I haven't gone through with a fine-tooth comb.
So on that specific change, there was only one change, and that was a change from referring to Wellington's tiriti partners in the notified guidance point to referring to Wellington's tangata whenua partners. It's correct that there were no mana whenua experts in the room to advise on the meaning of that change, and we were all relying on our understanding of those terms, although I note that we've gone from a term that's not defined in the RMA to a term that is defined in the RMA, tangata whenua. So I think there's a level of comfort around the understanding in a statutory context. But you're correct, there was no mana whenua advice on the change of that term.
Yeah, and I guess, is that consistent with the rest of the plan in terms of is tangata whenua or mana whenua?
So we'll note, I think there are some aspects of where it's tangata whenua versus mana whenua in terms of language use, but certainly I think it was felt that tangata whenua aligned with the tangata whenua chapter that's in the plan, so I believe it's part 1, and general use. So part of that was obviously the RMA definition, but also just generally alignment with how the plan refers in the tangata whenua chapter as well. Yes.
There was one other that jumped out at me, and I could be completely wrong because I've read far too much, but was it whakapapa of place, and that terminology has been removed? Is that correct? So I just wondered, you know, was there a wider meaning in that, and how was that, you know, how did that process go through to find that the removal of that word was appropriate?
Yeah, that was a matter that the experts are pretty consistent on, and that terminology responding to whakapapa of place has been amended to responding to context as a title for a guidance point, so not as the guidance point itself.
Nothing underneath changed it, it was just the title.
The guidance point underneath it certainly did change, but not with not with respect to the change in terminology from whakapapa to context. In terms of the essence of the guidance point below it, it still retains identify and respond to the unique value characteristics of the natural, built and cultural environment within this. So it retains a holistic context response, which was the original intent of that guidance point as well. So in that sense, and the guidance point didn't use a Reo Māori term in that respect. It was just the title above the guidance point that did. But yeah, that was there was strong direction to change that to responding to context.
Further questions? No. We'll take a break for lunch. We're about 10 minutes overdue. 1:30 or you do.
Just have one question from Mr. Banks. The answer that you gave me earlier about the insert into the design guides about relevance, has that been consistently applied across all of them?
Yes.
Thank you.
Yes.
The hearing will be adjourned until 1:30 for lunch. Thank you very much.
Yeah.
Good afternoon, everybody. The wrap-up hearing for the IPI provisions of the Wellington proposed district plan has been reconvened after lunch, and we are continuing with our discussion, our questions over the design guides and their relationship to the district plan. So I'll just see if there's any further questions from the panel before I've only got a few more. Please no. Okay, I'll start. One thing, Mr. Heel Whakaingaora has used a different phrase. Rather than fulfill the intent, he said achieves the relevant design objectives and the design outcomes of the relevant design guide. Lots of relevancy there. And I was just thinking whether that might be a better phrase. Why did you think that that was not as good as fulfilling the intent?
So sorry, just to check that he was referring to fulfilling the intent of the relevant design guide.
Yes, so in his track changes, sorry, for various policies, say CCZP10, he's crossing out fulfilling the intent and saying achieving the design guides of the centres and mixed, blah, blah, blah. So as an alternative phrase, given our discussion this morning around design outcomes and things.
Yeah, I mean, probably my view is that I'm still comfortable with fulfills the intent, and I understand his direction that he's coming from in terms of specific design guides, but I think as well intent is broad enough to capture the design outcomes in the guides and also of the guidelines as well, and I think it brings it up to that appropriate level by saying fulfills the intent of the guide itself rather than going into achieves the guidelines. I would also just say, reflecting after lunch, that I agree that there can be just some policy title clarification for the centres mixed use zones in terms of that focus on development outcomes, removing the word design because I see how it has created some confusion there as well. So I'm definitely open to that suggestion. But in terms of the wording, probably my comfort level is what I proposed, which also aligns with the notified wording as well in terms of focusing on the guide itself rather than guidelines specifically, noting that there are the outcomes as well. But I don't know if Mr. Banks has anything to say on that.
The issue of the connection between the policy that engages the design guide and the content of the design guide itself was a matter that came through in our review process and was referred to in the expert conferencing. We sought to address that. Certainly in the notified design guides, we as a review team considered that there was an unclear link, and working as we were on the basis of the notified policy, which was fulfilled to the intent of the design guide, what we've done in our newly formulated introduction, which is consistent across each of the design guides, is, as the experts have pointed out, we've included a statement of intent. But the point of that is to create a bridge between the policy, which refers to fulfills the intent of the design guide, and the content of the design guide itself. And so there is the statement of intent at the beginning. But what's actually really important about that statement is the second sentence of that statement, which I'll read out, is the design outcomes and guidance points contained within this design guide set out how development can fulfill this intent. So what that does is that creates a link between the guidance points and design outcomes, which themselves are explained in terms of what they are in the introduction section, and then the policy, which fulfills the intent of the design guide. So we've tried to make a connection right from the most detailed aspect of the design guide, which is a guidance point, right through up the chain to the intent, then to the policy. So and we consider we've addressed that through the review process.
Thank you.
So putting that into a section 32 context, presumably both Mr. Hill's method and the method that Ms. Stevens has supporting, or both achieve a similar outcome. It's a question of which is more appropriate.
Without, yes, or at least which is clearer to interpret.
Yes.
So within the context of the policy that was notified fulfills the intent of the design guide, we've made that link inside the design guide.
Yes.
To how the intent can be fulfilled, to make it clear.
Yep. And that guide is sitting inside the plan.
Mm-hmm.
It's in the introduction.
It's in the introduction.
Yeah.
Of each individual guide, that separate introduction document.
Yes.
Yeah.
Have you got Mr. Hill's wording in front of you? Because when the chair read that out, I saw two elements to that he talked about the design guides, but also the policies of the plan, which was almost a broader construct, not just those relating to urban design outcomes. Could you just read that out and then give us your comments on that?
Sorry, just bring it up now.
And presumably this was a standardised wording that Mr. Hill had recommended in all of the relevant provisions that trigger the design guides.
So it was replacing the term fulfilling the intent of,
yes,
with achieving the design outcomes of.
Is that, and nothing else? Was no other track change?
Not for that clause of the policy, no.
You were.
Not quite what I heard. Quite wrong.
Finding it.
There's a slight change to the overall beginning of the policy, referring to, requiring significant new development, and then it refers to positive contributing to the sense of place. He's got rid of the distinctive form, and then referring to the quality, has removed the amenity and instead put planned urban built form and function.
It's another issue. Yeah.
But in terms of the clause, the reference to the centre's design guide, it's just that change to achieving the design outcomes of.
Achieving the design outcomes as opposed to fulfilling the intent. Just achieving the design outcomes of.
Oh, the centre's a mixed use design guide.
Okay, well, the design guides as opposed to. Yes.
Intent of.
Okay. So it's for you, Mr. Banks, it's about clarity. Okay. Thank you.
That's right. I've got a question around the subdivision. You said that scope doesn't exist to support Mr. Ray's changes to the subdivision, and you saw his response to that, or was it in the legal submission somewhere?
It might be the legal, I think. I would need to refresh myself on that, sorry, in terms of.
Well, I think the point, if I summarise it correctly, was that Aura sought to delete the whole subdivision design guide, so anything less than that is within scope.
Right. Quite a broad scope. I think, I talked about the baseline in terms of, I think, obviously what was first and foremost within scope, but my other criteria, which were in my rebuttal evidence, was trying to be clear in terms of how I'd judged, looking at each submitted expert evidence, their suggested changes, I guess having an equal lens to it in terms of whether a change was appropriate, and not only kind of, I guess, that scope thing, which is one thing, and I can speak to that, but I think more importantly, what had the JWS agreed to, what was the recorded position, and I kind of didn't agree with the change where it just seemed to be from one submitter or didn't align with what the group had agreed to as part of a very clear process. In terms of scope, I guess I can speak to that more in a written response, but in my mind, it's not that specific in terms of scope, and noting that, they sought to delete it. Their change, unlike other submitters who have probably provided more scope in my mind, whether they've said amend or change design guide, is quite different to delete, and then suddenly delete is the ability to amend the guide. I don't have an entire comfort with delete, therefore you can go about changing the guidelines. But
I think just looking at the legal submissions, they also sought for the opportunity to review design guides if they were to remain a statutory document. So they've got delete at one end, excuse me, and review at the others of their scope spectrum, if you like.
that was within their original submission.
I'm just reading their legal submissions, so at paragraph 211, that's how they've worded it. So yeah.
Possibly at a crude form, they have had the opportunity to review as part of Mr. Ray being within this group. And I note that I did, not the subdivision design guide, but definitely for the residential and centres of mixed use, where he's identified a change that other submitters agreed with. For example, I think there was some text in the introduction. I've agreed to that, but in terms of subdivision, I did not agree with that change. Yeah, but I can respond further to that. I don't know if Ms. Banks wants to say anything.
Just to be clear, in terms of the expert conferencing, the subdivision design guide was not subject to the expert conferencing.
Just going to ask that. So I'm left with a bit of confusion or uncertainty. He's provided a commented version of this subdivision design guide, and I'm not sure where to take that at this stage in proceedings, late stage in proceedings. Have you got any thoughts or comments on that?
Understanding with the subdivision design guide and the heritage design guide was that in terms of the direction from the minute, I think I'm correct in saying this, it was really the flow on changes from the structure of what the changes made to the residential and centres and mixed use, which is reflected in the appendices of the Bottomist report in the latest subdivision design guide that you have. In terms of content, my understanding was very much focused around what submissions there were. Noting Ms. Duff was also responded to that as well in terms of the scope of evidence. In terms of those changes, I just didn't feel that it was the right time, given the stage and everything that had been gone through with the review process, to then be suggesting changes to subdivision design guide, given the focus was on the structural change. And it actually, as Mr. Banks has said, that actually during the conferencing subdivision design guide, the content wasn't analysed because there wasn't that direction there in the minute. No. So yeah, it does feel quite late in the stage to be making those changes, obviously up to the panel in terms of consideration, but I think probably doesn't align with the process it's been, and possibly would need to be considered more widely by experts in terms of the suggested amendments.
Yes, I mean, I will ask him the same question about what does he want us to do with his comments. In the absence of a track changes view of his idea, what the provisions of the design guide should say. But even then, even if he did provide us with a track changes version of his ideal subdivision design guide, we're not urban designers. We haven't got that role to agree or disagree necessarily with that kind of level of technical expertise. So, as I said, I'm not quite sure what to do at this point.
That, yeah, and possibly if that's provided, it would be good to have an opportunity for, say, Dr. Zamani and Ms. Duffel to review that if that is put forward.
Yeah, cool.
Yeah, and I guess that same question comes into my mind with regards to the heritage design guide, because there were submissions with regards to the content, but of course that all has been banked because of the review of the design guides in general. So there is a gap somewhere that needs to have clear information.
I'll pass to Ms. McCutcheon just because in terms of content that was addressed in Stream 3, Section 42A, hence why I didn't kind of replicate in this one, and noting that Mr. Kelly did withdraw his evidence.
Just to quickly close the loop on the Heritage Design Guide matter. So the recommendation in Ms. Stevens' report is that the Heritage Design Guide is confirmed in its new structure with the changes that I have recommended as part of Hearing Stream 3. So they might not be reflected in the version that's in front of you as part of this work because, they are perfect because the review picked up on those amendments earlier. So the Heritage one, all the submissions are done and dusted. They've had accept and reject and been addressed. and they reflected in this new structure and format. As for the subdivision design guide, all of those submission points have got acceptance or rejected statements as part of Ms Stevens 42, and those submitters have had the opportunity to consider whether they agree with those or not.
And on that point, I realise Ms Dovell's been very patiently sitting there waiting for, but one question I had for you was in relationship to your para 26, where you talk about the subdivision design guide. And you mentioned that you consider there's some repetition of landform and earthworks related matters that might benefit from consolidation, but you haven't necessarily taken that to a recommendation point here.
No, I was aware that there were, I was not part of the actual rewriting of the guides. So that was just a very high level, something to look out for those who are doing the redrafting.
Okay. Thank you. Any questions for Ms Dovell while she's there? I was going to say on the stand, but that's not right. No. One outstanding question for you, Ms Stevens. In your section 42A report, of course I won't be able to find it in a hurry, you were waiting for the joint witness statement to come to a conclusion about 3 matters. Let's see if I can find it. Yes, in paragraph 195, page 33, there are 3 sets of recommended amendments from the joint witness statement. And you said in paragraph 197, you're inclined to agree with Dr. Zamani on these outstanding matters, but unable to come to an informed decision until further expert evidence is received from the remaining parties. Now we've had that, and we've had your reply. So, and so just to confirm that your reply covers this point.
Yes, correct. So I think, so for 197, it was just reflecting the fact that was Dr. Zamani's statement evidence that I had at the time of drafting this 42, but obviously reviewing other submitted expert evidence in the realm as well. But what is reflected in my rebuttal in terms of my conclusions on that evidence is my position.
Okay.
Correct.
If no further questions, any further questions from the panel?
I just wondered whether you have road tested the design guides, you know, to see how they work, you know, to achieve, you know, the buildings that you're trying to achieve, whether you've gone through any scenarios of consenting scenarios or seeing how they would work in the real world, if you like.
Dr. Zamani has gone, because I more than suspect that happened at the original stage of design guide drafting. I don't know if
I realise it
comment on that.
The original stage. I just wondered through.
No, that's okay. No, so I guess probably the most vigorous review was during the expert conferencing and design guide review process. In terms of myself, I haven't done that analysis, but I kind of had confidence that they would have had during the original drafting stage. But I don't know if Mr. Banks has any comment on that.
Look, we're obviously, when we're doing the review process, we're mindful that we'll be getting expert input from a number of experts. The way the process actually evolved is that we had 3 conferencing sessions, and the first conferencing session was about higher level principles for a review, which we then followed through with establishing some principles for a review. And once we'd established those principles, we prepared a draft reviewed design guide, which we then tabled to the experts for their conferencing. And that's eventually what the joint witness statement ended up being based on. As part of preparing those draft design guides, we did have an urban designer in the team who road tested the drafts that we prepared against some consents, and nothing was raised in that testing that would that caused us to think that the review needed to change course or anything. So we didn't document that in our report, but we did do that internally, and nothing significant was raised that was problematic as a result. So, yeah.
Question about Mr. Owen from Willis Bond, I think, who I think he sought further clarification regarding vegetation and planting. In your rebuttal, Ms. Stevens, at para 39, you've not recommended an amendment for 3 reasons, but you've only listed 2. So should it be for 2 reasons, or is there a 3rd reason that we should know about?
Just read one moment. They very may well have, and I think possibly it's a chance for me to reflect on what that is. But I know that the crux of it was that in this case, in the appendix table, in terms of the expert conferencing joint witness statement, where it goes to, the changes made. In this case, I didn't agree with the change because I know that there was, from memory, a lot of discussion on this guideline, and I think probably differing views, but there was a conclusion as to amended text. So I didn't feel comfortable recommending a change from one expert where there had been a lot of kind of caucusing of an agreed position. And also, I think kind of the crux of it is that another key change is that it does change it from kind of that tier system of I get this the right order, directive to consider. And so I think that's quite a monumental change, and something it would be good to more broadly canvass if it was to be amended. But I think given the position agreed in JWS, that's probably why I didn't make the change. But I will reflect in case a 3rd comes to mind.
And that's what he was seeking, wasn't it? For it to be a consideration rather than a directive. Yeah.
It's possibly a question for Dr. Zamani. I think he actually addressed this in his evidence as well, G4 from memory. And if my memory serves me right, there's kind of enough flexibility within that to still consider, and it was important to still consider existing trees on the site in terms of coverage and the benefits landscaping wise that it provides, without me being a designer. But yeah,
sure.
But I'll get back to the panel if I remember what the 3rd thing is.
Thank you. Just shows that I read your evidence.
No.
In your supplementary evidence, Ms. Stevens, and 28, page 10, you've set out how you have actually dealt with each and every issue that has come up. And the very last bullet point on that page is where a change has been recommended that was not addressed by the JWS, nor have other experts identified this change. I have disagreed and not recommended any changes. Does that mean you have not actually done any consideration of those proposed changes?
I definitely reviewed each change. My position there in terms of that was that, again, I guess if a guideline or a change wasn't included within joint witness statement, in terms of the process to be in, which I feel has been rather equitable in terms of the submitters that have agreed to this position, that have been involved in the conferencing, I didn't feel comfortable making that change if it's something that hasn't been brought up in other expert evidence. So that was kind of, I guess, a bit of my guidance point in terms of why I haven't made that change. In terms of an exact one I make through that, I would also have to check in terms of scope as well and which guideline it relates to. But it definitely has been considered in terms of it, but that was kind of the guiding principles for how I came to a position that was, I guess, followed a proper regime of thought process rather than kind of an ad hoc decision making based on different changes.
So those considerations would then have been in the hearing stream accordingly.
Yes, I believe so. In terms of it would have been all within the expert evidence of the submitters within this wrap-up hearing. If that makes sense. Yeah.
Okay.
Yeah, just one, and it was probably more for Dr. Zamani, but Mr. Banks might be able to help. In your supplementary statement, Ms. Stevens, paragraph 40, you talk about residential units receiving winter sunlight, and Mr. Owen and Mr. Lewandowski was sort of an amendment to that to put where practical. Has that actually been thought about in the Wellington context? Thinking about Central City, we had Stride, I always get them two mixed up, Stratum. Look at the old Cricketers Arms site on the corner of Taranaki and Vivian Street, and because of the shape of that block, there's a lot of south side residential in there. So if you're going to be achieving the intent of the design guides, how are you going to be able to ensure that all residential units achieve winter sunlight due to the orientation, and is that a constraint on development capacity because there will be that requirement or at least that consideration? I'm just wondering whether that was thought about or discussed at all in the JWS, or and you know, was there a practicality test put over that particular recommendation to that residential units have access to winter sunlight where it might not be possible depending on orientation?
Might pass to Mr. Banks, and then if there's anything further I can comment on.
There was significant discussion on this matter in the conferencing, and the conferencing outcomes with respect to this matter record that, I believe they record that there wasn't agreement amongst the experts on the outcome. And I think it would be of benefit for you to ask each of the experts, because what we observed in conferencing is that some experts are saying this is really important for good residential outcomes, you need to get sunlight. And some experts were saying, well, look, it's not practical. Like, there are certain parts of Wellington where you won't receive winter sunlight. And the context for all this is obviously the operative design guides do actually have a measurement in it, so they have a number of hours that you're supposed to achieve, and you know, there was push from some experts to reinstate that. Where it's landed is somewhere in the middle, which is more of a clear statement that locate and design living areas within residential units to receive winter sunlight. So it's clear what's expected. If it's not practicable, then there is that mechanism in the design guide to say, well, look, if you can't achieve a guidance point, how are you achieving a broader outcome around residential amenity in that regard? So there is a method within the design guide to find alternatives. Again, this all pops up to the fulfilling the intent of the design guide as well. So there was disagreement amongst the experts, and you may need to canvass their views to evaluate which is the one you might want to fall down on. Where we've landed is something clear, but not so prescriptive as specifying a number of hours that you have to achieve.
Yeah, and it applies in both the residential design guide and in the centres and mixed use design guide as well. There's no differentiation between the two.
It applies to both, but in the centre of mixed use design guide, it only applies to residential activities. Yeah.
Which we've been told that there's a significant number already and a significant number enabled as well. Okay, no, I will ask that similar question to other experts.
I could just follow up on that, Mr. Banks. You chose your language quite carefully in that answer. You talked about non-compliance with the guidance, and then you distinguished that with non-compliance with the outcome.
Mm.
So the question that Commissioner Days asked you about what happened is the outcome being set up to perhaps fail.
It's hard to talk about this without a specific like development scenario, because even if you look at a purely south-facing elevation, that won't receive winter sunlight, right? Because it's always going to be beyond that angle. But are there ways within a residential development as a whole where people can have access to sunlight in a communal outdoor living space or a communal interior living space? I'm not sure. There are other methods that are less perhaps less direct. The design guide doesn't preclude those from being explored on a case-by-case basis. It would be like, as worded, the intent is relatively clear, so it would be an uphill battle.
Yes.
And so the question is, how much of an uphill battle is the panel willing to make it?
And I understand what you're saying.
Yeah.
Because the test isn't compliance with the guidance, it's compliance with the outcome.
It's fulfilling the intent, which is given effective to the outcomes, and the guidance provides a kind of an acceptable solution to the outcomes, right? So,
although as you've acknowledged, there could be alternatives.
Yes, correct.
Yeah. But either way, I mean, where there's no alternatives and access to winter sun, generally it's not achievable, such as the example that Commissioner Dace gave you. The outcome's not going to be fulfilled, is it? And because it's not practical to fulfill it.
I'm just going up to the outcome.
Yes.
So the outcome to which it relates.
The number.
So 017 relates specifically to internal environments.
Yes.
Internal environments provide healthy, comfortable, convenient, functional, and attractive places for their occupants. That doesn't say you have to have X amount of sunlight.
I understand that.
Yeah. So there are, through design, ways of addressing that outcome. But if a guidance point isn't being met, there would likely be focus in a consenting process on why it's not being met, and is it reasonable for it not to be met in the context? And that would become part of the actual assessment process in a consent context.
Yes, it would be a matter of discretion.
Yeah.
Go to the guideline that doesn't fulfill. It might be that the answer is no, it doesn't.
Yeah, could be.
Is that fatal?
Well, and that then goes back to the policy wording, not the wording of the design guide.
That's right.
Yeah.
So doesn't that, what you've just outlined, indicate that a web practicable test is actually appropriate for that? Thank you. Sorry, I really am focused on the central city with this. I think there's potential with multi-unit residential, MRZ and HRZ, to actually be able to look at that in more detail, because you don't have 100% site coverage as the expectation is in the central city, or as much of up to.
So to give you probably an unsatisfactory answer to your question, bearing in mind my role is not the expert on urban design matters here, what I would say in response to your question is some of the experts would tell you that it is not appropriate to have a practicality test, and some of the experts are saying you should have a practicality test.
Fair enough. Nice fencing, Mr. Banks.
I mean, where the emphasis will come will be on the reporting officer in the 42A and the resource consent, and the urban designer might say, well, the guidance is not met, the intent is not met, then the planner has to decide whether the policy is breached in a significant manner. And I think all Mr. Davis was saying is, and I think as a general view, this panel's, well, I won't say that. The avoidance of qualifiers is understood, but in this case, is this an exception where a qualifier might be considered because of the unique circumstances of Wellington City and the scenario that Commissioner Dace outlined, and particularly for Central City residential multi-unit development.
If I can just add two things as well, just in terms of that power reference. I guess firstly the benefit of talking to other experts, as Mr. Banks has noted, because I just note while Mr. Owen was involved, sought to be involved in the urban design expert conferencing, Mr. Lewandowski wasn't, or Stratum wasn't. I also note that my kind of consideration was as a non-urban designer and just being an observer in the processes, that qualifier would change that tier system from a directive to a consider. But there's good food for thought in terms of, for the designers, and also to put to them is there an area-based focus to it based on what you've just mentioned?
So is it currently a directive, sit in the directive?
It's at top tier, it's directive, and I think that's, and correct me if I'm wrong, Andrew, but I believe it was that generally there was comfort, or maybe could have been disagreement, but with the fact it stayed as a directive rather than consider in terms of what it's trying to give effect in the outcome.
Can I just add to this, because this was every change to the guide, the design guides has a life to it, and actually the life of any change is recorded in these kind of detailed tables, which at the back of our report. They're quite dense, but the purpose of that is so you can track what was notified right through to how the expert conferencing influenced the outcome. And this is one where we took a draft recommendation to the experts, which read, locate and design living areas within residential units to optimise exposure to available winter sunlight, right? So that's that is probably more in line with the practicality test, but through the conferencing and the agreed outcome, it was made much more explicit to, and this is through track changes which were identified in the conferencing outcomes. So, again, we felt obliged to take that expert. We had no very strong reason to reject that expert conferencing outcome. So I'll leave that with the panel.
Yeah. Useful.
Okay, thank you. Questions? All the questions the panel have. Thank you very much.
Thank you.
We are scheduled to resume the hearing tomorrow at 9 o'clock, when we'll start to hear from submitters and their experts. Until then, the hearing is adjourned for the day. Thank you very much.